NBA prayer one after the other. Sorry, I will take the NBA prayer, but if you know it, you can just go ahead with me. Almighty God, our Creator, we pray you be with us in all our deliberation and to direct our endeavors so that we shall continue in all humility to glorify thy name and do that which is right and just for our profession, its members, our fellow men, and our countrymen. Amen. Please put your hands together. Thank you very much. The president of the Nigerian Bar Association, Mazi Afam Osigwe, our own Director General of the Nigerian Law School, the Chairman MBA Legal Education Committee, distinguished colleagues, it's my honor to welcome you all to the 2026 Legal Education Summit with the theme Accelerating Legal Education Reform in Nigeria, Progress, Problems, and Prospects. Today's gathering is not just a mere meeting minds, but a convergence of a vision, a collective resolve to strengthen the foundation of legal education, to address its challenges, and to chart a progress path, the future of our profession and our nation. On behalf of the MBA Legal Education Committee, we want to welcome you to this event, and I believe at the end of this event, we'll be able to have resolutions that will take the legal education in Nigeria forward. Without wasting much of our time, we would like to invite the chairman of the MBA Legal Education Committee for his opening remarks in person of Professor Damilola Olawuyi, Senior Advocate of Nigeria, as he comes up to give us his opening remarks. Please, let's give him a resounding applause, please. It's not easy to put together this event within the shortest time. Please keep clapping until he comes to the stage.
The president of the Nigerian Bar Association, Mazi Afam Osigwe, Senior Advocate of Nigeria, the Director General of the Nigerian Law School, history maker, record breaker, Dr. Olu Gbemisola Titilayo Odushote, our distinguished keynote speakers that will be introduced shortly, the Secretary General and members of the National Executive Council of the NBA, my lords, distinguished judges and senior advocates of Nigeria here present, our invited panelists, guests, the Secretary and members of the MBA Legal Education Committee, Your Excellencies, ladies and gentlemen, it is indeed my great pleasure and honor as chairman of the Legal Education Committee of the Nigerian Bar Association to welcome you all to the 2026 Legal Education Summit convened by the Nigerian Bar Association and organized by our committee in partnership with the MBA Institute of Continuing Legal Education. The legal profession worldwide is undergoing fundamental changes. Not so long ago, being told to think like a lawyer meant having advanced oral advocacy and critical thinking skills to spot legal risk and win cases in court. However, in today's increasingly globalized marketplace, where a lawyer in Nigeria can be advising clients from Australia, from Saudi Arabia, or England, thinking like a lawyer today now includes blending knowledge of the law with project management, data analytics, and artificial intelligence, technology innovation, and sharp entrepreneurial legal skills. Over the last years, stakeholders in the legal profession in Nigeria have therefore clamored for functional legal education that keeps pace with these rapid transformations. However, due to a wide range of factors, including perennial underfunding of our universities, poor infrastructure, lack of modern technology, and poor working conditions of lecturers, many of our universities have struggled with the realities and needs of contemporary legal education, research, and clinical training. Given the critical importance of our profession to the sustainable and socio-economic development of the nation, repositioning and financing legal education to meet the needs of today and the realities of tomorrow has become a national priority. Just as the society is not static, the training of lawyers cannot be static. And this is why the NBA National Executive Committee, under the distinguished and charismatic leadership of our talk and do president, Mazi Afam Osigwe, Senior Advocate of Nigeria, swiftly constituted our committee in 2024 with the primary mandate of promoting and advancing functional, contemporary, and technology-driven legal education and training in Nigeria. Over the last 2 years, our committee has worked tirelessly to gather opinion from all stakeholders, especially through our regional town hall program across the country. As well, of course, the regional town hall meetings was ably led by our distinguished member and learned silk, Professor Chimezie Kingsley Okorie, Senior Advocate of Nigeria. We also had our online webinar series that have featured eminent legal professionals, practitioners, scholars from home and abroad. We thank the National Universities Commission, the Council of Legal Education, the Nigerian Association of Law Teachers, the MBA Lawyers in Academia Forum, the Network of University Legal Aid Institutions, NULAI, as well as other stakeholders that have participated in our surveys, regional town hall meetings, and webinar events. We have captured all your thoughts and recommendations and have put them in 2 milestone documents that will be presented and launched today, namely the MBA Standards and Rules on Legal Education, and secondly, the Journal Special Issue of the Journal of Sustainable Development, Law and Policy on the theme, Legal Education and Sustainable Development. Today's summit is therefore a glorious culmination of our 2 years of service. We thank Mr. President Mazi Afam Osigwe, Senior Advocate of Nigeria, for placing legal education at the top of his bold reform agenda of the MBA, and for the trust reposed in our committee to steer this important conversation. It is our hope that the proceedings of today will help the MBA and all stakeholders to reimagine innovative approaches for the transformation of legal education and training in Nigeria. Beyond today, it is also our hope that repositioning legal education will remain top on the agenda of the MBA. We specifically call on Mr. President to ensure that this summit is not a one-off event and that it occurs at least every 2 years. No round of applause for that. We also hope to see the Legal Education Committee represented in the National Executive Council of the MBA, in the body of benchers and other important bodies, so that we can continue to mainstream today's discourse permanently in the governance of the legal profession, thereby ensuring that legal education continues to meet current realities and future needs. Let me conclude by specially acknowledging the pragmatic and can-do spirit of the local organizing committee of this summit, under the able leadership of Professor Kamal Daoud, as well as Ozioma Soludo, the co-chairman of the local organizing committee, our ever proficient Secretary of the Legal Education Committee, Dr. Jonathan Ekpurusi, the alternate Secretary, Folashade Abiodun, as well as other members of our committee, and I've seen them, they've been here since morning, ensuring that everything is in order. By the way, the MC is also a member of that committee. I salute all their efforts. I salute their selfless contributions and dedication, without which this summit would not have been possible. Excellencies, distinguished ladies and gentlemen, the stage is set. Our eminent speakers are here and ready, so I will not stand in their way. I wish everyone a rewarding and successful 2026 Legal Education Summit. I thank you all.
Thank you very much. Please, can we make that round of applause a little bit louder? Mr. President, distinguished learned senior advocates of Nigeria, erudite professors of law here present, just to inform us that we also have in our midst the chairman of the Council of Legal Education, none other than Chief Emeka Ngige, senior advocate of Nigeria, OFR. You're welcome, sir. We also have in our midst the representative of the Honorable Attorney General of the Federation and Minister for Justice, who is ably represented by Mrs. Gladys Odebaro, a director in the Federal Ministry of Justice. You're welcome. We also have in our midst the first Vice President of the Nigerian Bar Association, Sebastian Anya. You're welcome, sir. Distinguished ladies and gentlemen, we have in our midst Dr. U.E. Okolocha, who represents Professor Dakas C.J. Dakas, the chairman of the Nigerian Law Reform Commission. Prof, you're welcome, sir. We also have in our midst Professor Peter Akpe, senior advocate of Nigeria, OFR, a research professor of law with NIAS, who is representing Professor Abdul Kadri Abikon, the DG of the Nigerian Institute of Advanced Legal Studies. Prof, you're welcome, sir. Ladies and gentlemen, as we receive our distinguished guests, we'll continue to recognize them. But I know for a fact that Professor Yuyu Chukwumaeze is here with us. Prof, you're welcome, sir. Prof is the Vice Chancellor of Imo State University. Prof, you are highly welcome. We also have in our midst Mr. Yakubu Philemon, Senior Advocate of Nigeria, Learned Silk. You're welcome, sir. We have in our midst B. Lawal, Senior Advocate of Nigeria. You're welcome, sir. Thank you very much. Of course, distinguished ladies and gentlemen, without taking much of your time, it's now time for us to invite the president of the largest bar in Africa, the 32nd president of the Nigerian Bar Association, Mazi Josiah Afam Osigwe, to give us his remarks. Please, can you put your hands together? It's always interesting when the town comes to gown, but today I think the gown has come to town. Thank you very much.
The chairman of the Council of Legal Education, Chief Emeka Ngige, Senior Advocate of Nigeria, the Director General of the Nigerian Law School, Dr. Olugbemi Shoga Odusote, Professor Yuyu Chukwumaeze, the Vice Chancellor of the Imo State University, Prof. Damilola Olaomi SN, the Chairman of the Legal Education Committee, members of the National Executive Council. Professor Peter Akpe SN, representing the DG of the Nigerian Institute of Advanced Legal Studies, Professor Ibrahim Abiko, learned senior advocate. Let me adopt the already established protocol so that I don't omit any person. Deans of law and every person, you're duly recognized. I was thrilled when Prof and his committee indicated that they wanted us to have this summit. And when I saw the topic chosen, then it confirmed to me that we're all in agreement that there is need to reform legal education in Nigeria. But when they talked about accelerating it, I said to myself, just maybe, we're so much behind in time that we have to move very fast to catch up with the other parts of the world, especially in the within the Commonwealth and common law countries. And so I joined the chair of the committee in welcoming all of us. And I'll start by noting that it is generally believed that a good education should not only teach skills, but also help broaden one's horizon, gain better perspective, and teach one to think for oneself. A good education, therefore, increases chances for better career opportunities, provides financial stability, makes one's dreams come true, promotes critical thinking, builds confidence, helps one learn about other values and morals to have a well-balanced, open mind, and gives us the skills, technique, information, and knowledge to know, understand, and respect the duties we have towards our society, families, and nation, etc. Legal education in terms of academic and vocational training is a vital ingredient that affects the quality of our justice delivery system. It is therefore not in doubt that legal education is a continuous process. It does not end after university studies, law school, getting postgraduate degrees, or even becoming a professor or senior advocate of Nigeria. Legal education should be a continuous process because the law changes as humanity evolves. Hence, an educated lawyer must stay educated through continuing professional development. It is generally said that a lawyer can only be as good as the system of legal education that produced him. Legal education, academic as well as vocational, is therefore a vital ingredient that affects the quality of our justice system and the role of lawyers in the political, economic, and social development of our country. The imperativeness of a system of legal education that can produce lawyers with necessary skills and capacity to meet the evolving needs of society has always been emphasized. In 1933, Lord Sankey observed that the courts are becoming more and more concerned with great social experiments. Law joins hands as never before with problems in economics, problems in political science, problems in techniques of administration. It is important that the curriculum of our law schools, should send out lawyers trained to appreciate the meaning of these relationships. They must shape the mind to a critical understanding of the foundation of jurisprudence. Unless the training we give supplies these perspectives, there is a grave danger that the lawyer will not prove adequate to the big problems he has to help in solving. Our educational methods have to breed a race of lawyers able to utilize the spirit of law reform for 22 highest uses. They have to teach at once the importance of stability and change. We must also turn out lawyers with a courage to criticize what is accepted, to construct what is necessary for new situations and new duties both at home and abroad, unquote. I must then ask a question. Has legal education in Nigeria achieved the prerequisites of education or legal education? Not many will agree that it has been largely successful in this regard. In a lecture titled Rethinking Legal Education in Nigeria to Meet the Needs of the 21st Century, Fabian Ajogu, SN, remarked that social education, sound education is a prerequisite for honoring the trust lawyers hold as legal practitioners. According to him, the world is a global village, and our economy as well as its needs are ever changing. Legal practitioners play an important role in ensuring the sanctity of the world. Hence, they must be trained to meet global economic complexities as they arise. Nigeria's legal education must be revamped to reflect these 21st century complexities, unquote. A guesstimate puts the number of young lawyers in our major cities who have or have had the opportunity of undergoing pupillage at less than 30%. Some may say this figure is much higher than the true figure. We hope that someday an accurate figure will be available so that we will not have to make any guess. Under the extant system in Nigeria, a young lawyer who has been called to the bar does not need to undergo any form of tutelage or pupillage before setting up or his practice, or as the Americans say, to hang out his or her shingle. In fact, the economic reality is such that a young lawyer who chooses to hang out his shingle or her shingle, or who is compelled by the inability to secure a job in a law firm, may not even need a physical office to commence practice. The advent of GSM has dispensed, and of course the internet has dispensed with this need in some major cities. With his mobile phone, many young lawyers have successfully commenced practice. There have been many calls to reform legal education in Nigeria. Prof, here I quote you. Professor Damilolo Olawi recently called for rapid reform of legal education in Nigeria in order to develop practice-ready lawyers who can contribute meaningfully to Nigeria's economic rebirth, unquote. According to him, the society is not static, so legal education cannot afford to be static. This is why he said at ABWAD, they actively infuse all their law courses with technology, innovation, business intelligence, and commercial awareness. He therefore called the Nigerian universities and Nigerian law school to embrace rapid pedagogical change by developing tailored courses that prepare law students for modern realities. I agree with you, Prof. Many agree that if lawyers, law graduates, have market awareness and entrepreneurship skills needed to move beyond traditional practice areas and become leaders in contemporary and economically important areas, they would be better valued, paid, and employed. Such a review must consider the desirability of the present 5-year length of study for the law degree, the course content of the university education, the course content and the thrust of the Nigerian law school, the possibility of licensing private law schools or legal education practitioners, the requisite qualification for sitting for a bar finals examination, etc. In a well-researched article titled Reform of Legal Education and Legal Profession in 21st Century Nigeria, Chima Omezurike posited that the duration of the LLB degree is too long. Nothing useful, according to him, is achieved by forcing a student to study the LLB for 5 years. He said 2 to 3 years should be sufficient for the study of the LLB program. After all, and I'm quoting him still, only these core subjects are what a person needs to be a lawyer. A person who is interested in an academic career in law can always go back to university and undertake postgraduate studies in law. Keeping a person in a law faculty for 5 years will not improve the quality of legal education. In order to improve the quality of legal education of lawyers, we should focus on primary and secondary education. A person who was not properly educated at primary and secondary education levels cannot be expected to improve his writing and grammatical skills in university. University is not the place for the acquisition of those basic skills, unquote. Justifying his view, Mezurike stated that there should be only compulsory, that these should be the only compulsory subjects for eligibility to sit the bar examinations. I am of the view that jurisprudence is not a core subject. In England, it is not a core subject. It is left to the individual university to decide whether it should be compulsory for the award of the LLB degree. However, it is not a requirement for entry into the solicitor's bar course. End of quote. Ordinarily, one is tempted to reason that if it is indeed true that many young lawyers who had 5 years of university education are not as good as the generation that did 4 years, then it will be counterproductive, if not illogical, to suggest that the years of university education be reduced. Such a dim view of the suggestion, in my opinion, is based on the unempirical evidence that better lawyers will be produced by longer years of training. I beg to differ. The practical and focused content of the university education will achieve a better result if it lasts for 3 years. In fact, some of the courses offered in universities are in reality subsumed under some courses that are of practical relevance to legal practice. It is therefore not surprising that I agree with a suggestion made by Chima Omezurike in the article referred to earlier, that only subjects in the LLB degree or equivalent that should be compulsory for eligibility to sit the bar examination should be the course subject. That is constitutional law, administrative law, criminal law, tort, contract, land law, equity and trust, and the Nigerian legal system. On the economic benefit of such a reduction, he said that reducing the length of the LLB program will help poor students. In England, the LLB program usually lasts 3 years. University of Buckingham offers a 2-year program. This will no doubt be a welcome relief for many law graduates who are increasingly finding it difficult to pay the law school fees, to talk less of clothing themselves, feeding, and shouldering other financial burden of other mandatory requirements of the law school. The use of legal clinic education as a form of instructional teaching, which combines substantive law with skill and values, and serves as a laboratory for practice on the basis that the primary aim of legal training is to preserve students for practice, should be improved upon. Legal education should assume sufficient responsibility for professional skills, training, and for exercises requiring the application of knowledge to concrete situations. The training should therefore introduce more active student participation teaching methods, e.g., example, the case or problem method of instruction, moot courts, workshops, and other practical exercises. There should be less emphasis on rote learning. Rather, students should be allowed to develop critical thinking and independence of thought. I also suggest that we should prepare for a day. Before I came up, I told DG I would try to shake the table. And so I hope this does not shake the table so much. I also suggest that we should prepare for a day when the present system of in-campus training for law graduates at the Nigerian Law School may be jettisoned. The increasing number of law graduates, coupled with the inability of the law school to admit them, may force a review of the system. Not to be forgotten is the increasing cost of in-campus training, fees and living expenses, that is. We may have to consider having law graduates who are admitted into the barrister at law program being supplied with a course and allowed to prepare for the examination without having to do in-campus training. The Constitution, as well as university laws, should also be amended to enable lecturers in government-owned universities to also practice privately if they are not non-tenured. Thus, universities should be able to employ tenured full-time and non-tenured part-time lecturers. We should develop physical in-person, virtual, and computer-based training models which incorporate practical aspects. The computer-based training models should be developed in such a way that a lawyer can register for the course whenever he or she chooses and then take an examination at the end of the program. The reform of legal education must look at legal education both as part of a broader, better planned education system and as part of the process of developing the legal system and society itself. Before I get there, let me say that the views expressed here are not that of MBA, but they are personal to me, because we are here to articulate our views. And so this does not represent the views of the MBA, but my personal thoughts as to some of the areas we may need to consider for reform. Thank you so very much for listening.
Let's give the president a round of applause. The president of the largest bar in Africa. Please keep clapping for Mr. President. Indeed, our legal education deserves to transform to experiential learning and critical thinking. Thank you very much, Mr. President. For me, this is the first time after a very long time seeing Mr. President read a speech. I've never seen him reading a speech before since I've known him. Please, let's give him another round of applause once again. It's just that I was scared when you were talking about the number of law school, and I checked the front row. I saw the chairman, Council of Legal Education, saw the DG of law school. I said, oh, I hope that we don't close down some law schools very soon, some law faculties in Nigeria. Please, let's give the MBA president another round of applause. We'd like to recognize the presence of Professor C.J. Ubanyo, Senior Advocate of Nigeria. I hope I pronounced that name very well. Thank you very much, sir. And also like to recognize the presence of some of my teachers. We have S.A. Oshamolu, the DDG of the Lagos campus of the Nigerian Law School. Thank you very much, sir. We also have Dr. Mrs. Caroline Oba, DDG Yanagwa campus, and she's also one of the panelists today. We also recognize the presence of R. Salma, DDG Yola campus. Thank you very much, sir. And we also have our own Dr. E.O. Onoja, is the General Secretary of NOLT. Please, let's give him a round of applause, please. Thank you very much. Without wasting much of our time, as we continue to have dignitaries coming, we'll continue to recognize Mr. President, Learned Senior Advocate of Nigeria, and our distinguished professors of law. Without wasting much of our time, we will now invite the representative of the Honorable Minister of Justice and Attorney General of the Federation, Mrs. Gladys Odegbero, Director from the Federal Ministry of Justice, for a very short remark. Thank you very much. She has whispered that she will only spend 1 minute, 30 seconds. Please, let's give her a round of applause, please. Thank you very much.
the chairman, the president of the Nigerian Bar Association, the chairman, the Council of Legal Education, the DG Nigerian Law School, the chairman, Nigerian Law Reform Commission, ably represented, and a representative of the Nigerian Institute of Advanced Legal Studies, Dr. Akpe. Please permit me to rely on the already established protocol. Good morning, everyone. I'm here to represent the Attorney General of the Federation, Prince Lateef Fagbemi SAN, who is unavoidably absent due to other exigencies of duties. So I'll proceed to read his address. He says, "It is a profound honor to stand before this distinguished assembly at the Nigerian Bar Association Legal Education Summit 2026. I extend my sincere commendation to the leadership of the NBA for convening this timely and consequential gathering dedicated to the theme, Advancing Legal Education Reform in Nigeria, Progress, Problems, and Prospects. This summit is not merely an academic exercise, it is a call to action, an opportunity to reflect on the strides we have made, to confront the challenges that persist, and to chart a bold course for the future of legal education in our nation. By bringing together thought leaders, practitioners, educators, and policymakers, the NBA has created a platform where ideas can be exchanged, reforms can be envisioned, and commitments can be forged to strengthen the foundation of justice in Nigeria. This theme speaks directly to the heart of our justice system. Legal education is not merely a preparatory stage for the profession, it is the foundation upon which the integrity, competence, and future of our legal system rests. I warmly recognize the presence of eminent jurists, distinguished members of the bar, esteemed academics, and the vibrant community of law students who represent the future of our profession. Your collective participation underscores the shared commitment to strengthening the pillars of legal education in Nigeria. This gathering is enriched by the diversity of perspectives in this room, those who interpret the law, those who teach it, those who practice it daily, and those who aspire to join its ranks. Together, we form a continuum of knowledge, experience, and aspiration that is essential for meaningful reform. As we reflect on the progress made over the years, it is evident that Nigeria has produced outstanding legal minds who have contributed significantly, both locally and globally. However, we must confront the realities of a rapidly evolving world, one defined by technological disruption, globalization, and increasingly complex legal challenges. Our legal education system must therefore rise to meet these realities. It must produce lawyers who are not only grounded in legal principles, but are also innovative, ethically sound, technologically aware, and globally competitive. It is no longer sufficient to rely solely on traditional methods of legal instruction. Among the challenges we face are outdated curricula that do not fully reflect emerging areas of law, such as digital economy, cyber law, and international commercial practice, inadequate infrastructure and teaching resources in some institutions, the need for stronger linkage between academic training and practical legal skills, and the necessity to uphold and enforce high standards across all institutions involved in legal education. Addressing these challenges requires a coordinated and sustained effort by all stakeholders. I particularly commend the Nigerian Bar Association for its initiative in developing the NBA standards and rules on legal education. This is a laudable step towards strengthening regulatory frameworks, enhancing institutional performance, and aligning Nigeria's legal education system with global best practices. Such initiatives are critical in ensuring consistency, quality assurance, and accountability across the board. As the Chief Law Officer of the Federation, I assure you of the federal government's commitment to supporting reforms that will strengthen legal education in Nigeria. However, meaningful reform cannot be achieved by government alone. It requires strong collaboration among regulatory bodies, academic institutions, the Nigerian Bar Association, the bench, and the private sector. As Attorney General of the Federation, I pledge to work with all stakeholders, universities, the Nigerian Law School, the bar, and the bench to ensure that Nigeria produces lawyers who are not only competent, but principled, innovative, and responsive to the needs of society. Together, we must build a system that fosters excellence, innovation, and integrity. Moving forward, our focus must include reviewing and modernizing legal curricula to reflect contemporary realities, integrating technology into legal training and practice, strengthening clinical legal education and practical skill development, enhancing faculty capacity and institutional infrastructure, and promoting continuous legal education as a lifelong professional obligation. If we get legal education right, we secure the future of justice in Nigeria. I also urge this gathering to deliberate further on ongoing amendments of the Legal Education Consolidation Acts as part of the reform initiatives to strengthen the Council of Legal Education, improve the governance of the Nigerian Law School, and modernize its curriculum in line with global best practices and tailor it to address Nigeria's realities. Distinguished ladies and gentlemen, the task before us is both urgent and achievable. The future of our legal profession, and indeed the administration of justice, depends on the quality of education we provide today. Let this summit not only be a platform for dialogue, but also a catalyst for concrete action and measurable progress. I once again commend the Nigerian Bar Association for this initiative and assure you of my continued support in advancing legal education reform in Nigeria. Together, let us advance legal education reform, and I thank you all for a productive and successful summit. Thank you.
Thank you very much. Please, can we put our hands together for the Honorable, the Attorney General of the Federation, who has assured us of the Federal Ministry of Justice's and the government's commitment to making sure that the education we provide for now is the education for the future. Ladies and gentlemen, without wasting much of your time, you will see that she spent just 1 minute and 30 seconds in presenting that very wonderful speech. So on that note, I would love to invite the National President of the National Association of Law Teachers, NALT, ably represented by Dr. E.O. Onoja. Please, can we put our hands together? And please, organizers would make sure that Prof does not go back to that seat. He has to sit somewhere in front representing our president, the president of the Association of Law Teachers. As he comes to give a speech, we want to recognize the presence of Al-Hassan Akije, Senior Advocate of Nigeria. You're welcome, sir. He's representing the chairman of INEC, Professor Joash Amopiton, SAN.
The president of the Nigerian Bar Association, Mazi Afam Osigwe, Senior Advocate of Nigeria, the chairman of the Council of Legal Education, Chief Emeka Ngige, Senior Advocate of Nigeria, Life Bencher, the Director General of the Nigerian Law School, Dr. Olugbemisola Titilayo Odusote. May I, on this note, crave your indulgence to adopt the protocol established by the president of the largest bar in Africa and to recognize everyone who is here. The president of the Nigerian Association of Law Teachers, Professor John Oluwole Akitayo, has asked me to deliver a very brief goodwill message, which is sent to me this morning. With your permission, I proceed to read his goodwill message. Goodwill message by the president of the Nigerian Association of Law Teachers. I appreciate the invitation extended to the Nigerian Association of Law Teachers to participate at the 2026 NBA Legal Education Summit organized by the Nigerian Bar Association Legal Education Committee. Legal education and the legal profession in Nigeria are intertwined. This has been evidenced as far back as 1959, when the federal government raised the committee, popularly known as the Unsworth Committee, to advise it on the future of legal education and the legal profession in Nigeria. The recommendations of this committee led to the establishment of the Council of Legal Education and the Nigerian Law School. The federal government also appointed the Professor LCB Goa Committee to advise it on legal education. The Goa model of legal education, a Nigerian initiative, has been replicated in many countries in the Commonwealth and beyond. The adequate representation of the Nigerian Bar Association on the Council of Legal Education, the statutory organ charged with responsibility for regulating legal education in Nigeria, underscores the trust that the Nigerian government, and I may say the Nigerian people, have in the Nigerian Bar Association. In some faculties of law, the chairman of the local bar association is a member of the faculty board of law. This is the situation at the University of Ibadan. There must never be a disconnect between legal education and the legal profession. The interest that the bar association has in training of future entrants into the legal profession is well placed, and it appears to be a universal phenomenon. A profession that ignores training of its future members does so at its own risk. NBA must see its members in the academia as critical stakeholders and active participants in the quest to build a legal profession that can rise up to the challenges of contemporary society. In view of the enormous responsibilities placed on teachers, teachers deserve respect and teachers deserve recognition. NBA as a body should be in the vanguard of promoting the professional recognition of law teachers. I think this is the president's coded word of saying the NBA should welcome more members of the academia into the distinguished rank of Senior Advocate of Nigeria. I continue. The theme, Accelerating Legal Education Reform in Nigeria, Progress, Problems, and Prospect, is therefore apt. It is broad enough to enable us interrogate critical issues in legal education. NALT looks forward to a more active engagement with both the NBA and its Legal Education Committee in recognition of its role in the implementation of the outcomes of this summit. I wish us a most productive deliberation. Thank you. John Oluwole A. Akintayo, President, Nigerian Association of Law Teachers, NALT. Thank you.
Thank you very much, sir. Thank you very much. Please, can we put our hands together once again for our president of the law teachers, of all the law teachers in Nigeria. Prof, we are really very grateful. I've also cited in the room Professor Emmanuel Akibe, the Dean of the Faculty of Law, Ambrose Ali University, Eboma. Prof, please, you're welcome, sir. So good to see you. Thank you very much. We also have in the room Daniel Teller, the Secretary of the Body of Benchers. You're welcome, sir. Thank you very much. We also have in the room the representative of the Dean of the Faculty of Law, University of Abuja, Professor Owakwe Abugu, ably represented by Dr. Franklin Obu. You're welcome, sir. Thank you very much. Without wasting your time, please permit me to invite for his goodwill message the chairman of INEC, ably represented by Dr. Al-Hassan Akije, Senior Advocate of Nigeria. I'm sure if you clap better, he will get here faster. with the assurances that the academics will guarantee that there is a free and fair elections next year.
The president of the Nigerian Bar Association, my president, chairman of the Council of Legal Education, the National Advocate of Nigeria, the Director General of Nigerian Law School, the senior advocates of Nigeria here present, professors of law, all due protocols observed, ladies and gentlemen. I bring you warm greetings from the chairman of the Independent National Electoral Commission, Professor Joash Amopitan, Senior Advocate of Nigeria, who regrets his inability to attend this program personally, but he has directed me to represent him, and here I am. So you permit me to deliver his goodwill message. I'm delighted to extend my warm goodwill to the leadership and members of the Nigerian Bar Association and all participants at this important summit on the theme, Advancing Legal Education Reform in Nigeria, Progress, Problems, and Prospects. This summit is both timely and significant. It demonstrates the commitment of the Nigeria Bar Association and other stakeholders to critically examine the current state of legal education in Nigeria and develop practical, forward-looking reforms capable of strengthening the quality, relevance, and global competitiveness of legal training in our country. The legal profession occupies a strategic position in the sustenance of democracy, constitutionalism, justice delivery, and good governance. Consequently, the quality of legal education directly affects the quality of our institutions and the future of national development. In a rapidly changing world driven by technology, globalization, and evolving governance challenges, legal education must continually adapt to prepare lawyers who are intellectually sound, ethically grounded, technologically aware, and professionally competent. I commend the Nigeria Bar Association for sustaining consultations and engagements with stakeholders across the country over the past 2 years and for consolidating those valuable contributions into concrete reform initiatives. I also applaud the formal launch of the NBA standards and rules on legal education, which will undoubtedly contribute to strengthening quality assurance and promoting best practices in legal training institutions. As chairman of the Independent National Electoral Commission, I recognize the critical role legal practitioners play in democratic governance and electoral administration. The increasing complexity of electoral law, digital evidence, constitutional adjudication, and regulatory compliance underscores the urgent need for a modern and responsive legal education system. There is no doubt that Nigeria possesses the intellectual and institutional capacity to reposition legal education for the demands of the 21st century. However, achieving meaningful reform will require sustained collaboration among the bar, the bench, universities, the Nigerian Law School, regulatory institutions, and policy makers. It is my hope that the deliberations at this summit will produce practical and implementable recommendations that will advance legal education and strengthen the profession in Nigeria. I commend the organizers for this laudable initiative and wish all participants fruitful deliberations and a successful summit. Thank you, and God bless the Federal Republic of Nigeria. Thank you.
Ladies and gentlemen, distinguished learned senior advocates of Nigeria, please can we give him another round of applause? Education remains the bedrock to a better society. Since he has told me not to talk about the next year's election, I choose not to talk about the next year's election, but only a sound professional education will produce lawyers that will represent litigants in the next year round of election petitions. Ladies and gentlemen, can we give him another round of applause? We know that in our midst today we have the Dean of the Faculty of Law, Lagos State University, Professor Karim Adebayo. Prof, you're welcome. Thank you very much. Thank you, Prof. Thank you, Prof. You're welcome, sir. Now, to draw a close on our goodwill messages, I would like to invite none other than the chairman of the Council of Legal Education, Chief Emeka Ngige, SANOFR. Please, can we put our hands together for him as he comes? It's also good for us to know that this discussion is not without the input of the students. And we have students from Nasarawa State University, KEFI. We have students from Nile University, University of Abuja, Bayes University, Philomath, and Veritas University here represented. You're welcome.
Thank you, MC. The President of Nigerian Bar Association, Mazi Afam Josiah Osigwe, Senior Advocate of Nigeria, Life Bencher, the Director General of Nigerian Law School, Dr. Olubemisi Odushote, members of the Executive of Nigerian Bar Association here present, all the members of the Inner Bar, Outer Bar, and members of the Planning Committee. As you can observe from your program, I was not built to deliver a goodwill message. Where my own Attorney General, my own supervising minister, has delivered a goodwill message, I think that should be the end. But I was invited, nevertheless, to come and say one or two things. So I start by congratulating Nigerian Bar Association for this summit, accelerating reforms in legal education. It couldn't have come at a better time. I recall that in 2022, we assembled at Afe Babalola University for a summit on the future of legal education in Nigeria. The theme was reimagining the legal education in Nigeria. And coincidentally, Professor Damilola Olawi was the chief planner of that summit at Ado-Ekiti. And I was also privileged to deliver a goodwill message. And that was under the regime of Mr. Bata as MBA president. And at the end of that summit, it was a 2-3-day event. A communique was issued containing 18 points communique. And at the Council of Legal Education, we received that communique, but at the time it was presented at the council, Olumide Akpata was on his way out as president of MBA. And then Mr. Y.C. Mekiao took over. And when this communique was represented for deliberation at the council, Y.C. Mekiao pleaded for time to go through the document and come back on the position of MBA.
because the communique contained a lot of far-reaching recommendations, including that law should not be a first-degree course, that the idea of people with lower qualification, that is only in Nigeria, according to the communique, that people with lower qualifications come to study law. And then he recommended also that proliferation of campuses of the law school should stop, among other recommendations. Unfortunately, YC Mekiao did not come back with the position of the MBA at the council, because the MBA occupies strategic position in the Council of Legal Education. MBA has 16 representatives in Council of Legal Education. So apart from the Attorney Generals of the states that are 35 or 36, the MBA is the next institution with representation that anything MBA wants the Council of Legal Education to do, it can be done with their number. But we were not able to get that input. So we are now meeting another summit. The president of MBA by August will be gone. Then another president of MBA will take over. You ask him, what are we going to do about today's communique? He will ask, give me time to study them. So the takeaway from today is the speech of the Attorney General of the Federation. The Attorney General has given us hint that there is currently a bill for the amendment of Legal Education Consolidation Act of 1962. So whatever resolutions or recommendations that we get from today's summit, MBA should not waste time to partner with Council of Legal Education and Federal Ministry of Justice to see that whatever that we agree that should be in that bill before the National Assembly passes it is reflected. And equally, we cannot also, in the legal profession, change the mode of legal education without the input of Federal Ministry of Education, without the input of National Universities Commission. So we must partner with these agencies in whatever we resolve today to ensure that the bill that will be passed will be complied with by all government agencies to ensure that legal education is what we are dreaming. There is no doubt that we are facing serious challenge. Just last week, we had a meeting at the Body of Benchers, and the meeting had one of the issues for the discussion in the agenda was the clamor by some students of Open University that they want to go to the law school willy-nilly. And Open University is not recognized mode of legal education. But we bent backwards about 3 years ago to accommodate 1,883 of such students whom they claim have graduated from that university. And when we have given them admission and admitted them in batches, they came with another number, 4,000 plus. That was when we knew that there is something serious. So we must be very vigilant about the state of legal education. We must not allow people to enter the profession through the back door. That's why this summit is very important. Whatever communique that is reached at today's meeting should swiftly be passed on to the Council of Legal Education and to the Honorable Attorney General of the Federation, so that the bill that is being processed can reflect our communique, our recommendation. Once again, I want to thank the MBA President for organizing this summit, thank the organizers, and thank all the participants, including my own Director General, who has been billed to be a keynote speaker at this summit. Thank you, and God bless you all.
Thank you very much. Please give him another round of applause. you agree with me that the choice of bringing him up here to give his own remark is very apt and very fundamental. If you are, please let's give him another round of applause, please. So without wasting much of our time, we will now go into taking the keynote addresses, and we'll start with our history-making Director General of the Nigerian Law School to come and give us a keynote address. Please give her a round of applause, Dr. Olugbe Mishola Titilayo Odushote, the Director General of the Nigerian Law School. Please give her a round of applause. Keep clapping.
The Honorable Attorney General of the Federation and Minister of Justice, ably represented by Mrs. Gladys Odegbaro, the President, Nigerian Bar Association, Maazi Afamosigwe, Senior Life Bench, the Chairman, NBA National Legal Education Committee, Professor Damilola Olawoye, Senior Advocate of Nigeria, the Chairman, Council of Legal Education, Chief Emek Ing, Senior Advocate of Nigeria, Life Venture, the Chairman, the Director General, Nigerian Institute of Advanced Legal Studies, ably represented, the Chairman of INEC, ably represented, fellow keynote speakers, Vice Chancellor, University of Ilorin and Imo State University, Learned Silks, Deputies Director General of Campuses of the Nigerian Law School, Deans of Law and all professors, ladies and gentlemen. It's a pleasure to stand before this gathering to present a keynote address, which I've titled Evolving Expectations of Professional Legal Training in Nigeria, aligning professional training to meet contemporary realities. Now, before I go on, I'd like to lay some foundations on two things. Number one, the legal education, and the president of the Nigerian Bar Association has alluded to that education continues. But I also want to say that there is the formal aspect of education or legal education, and then there's the informal aspect of it. And then I'll also want to say that when we look at legal education, I'd like us to picture a relay race. The first leg is the primary school, which is for 6 years. The second leg is the secondary school, which is also for 6 years. The third leg is the university, which is for 5 years. And the last leg is the Nigerian Law School, which is only for 9 months. So that if we look at that relay race, we'll understand that it's not evenly distributed. But notwithstanding, we've achieved what we've been able to achieve in Nigeria. And so we understand how the Nigerian Law School came about. The president of the National Association of Law Teachers spoke about the Unsworth Committee, and so I wouldn't go into that again, except to mention that the recommendations of the committee. Number one, Nigeria should establish its own system of legal education. Number two, a faculty of law should be established first at the college, University College Ibadan, and in other universities. A law school to be known as the Nigerian Law School should be established to provide vocational courses. Number four, qualification for admission to legal practice should be a degree in law of any university whose course for the degree is recognized by the Council of Legal Education. Number five, any person graduating in law from a university which has not accepted the syllabus recommended by the Council of Legal Education should be required to take such further examinations as the Council prescribes, and then the establishment of the Council of Legal Education. And so we know that in 1962, we had the establishment of the Nigerian Law School, the establishment of the Nigerian and between 1962 and between 1962 and 2008, we had 5 courses taken at the law school: civil procedure, criminal procedure, legal drafting and conveyancing, company law and practice, and general paper made up of law office management, professional ethics, legal practitioners, accounts. Now, this, the methodology then was just a lecturer going into class, lecturing for 1 hour, and then towards the end of the session, then students were introduced. I hope everybody can hear me. Okay. So towards the end of the session, the tutorial, so it was 1 hour, and so in a day, we had about 4 or 5 lectures. And then it was basically dictation. Lecture mode then was lecturers dictating notes and minimal contact. I mean, in those days, you can, for those of us who were at the law school then, we had minimal contact with our lecturers, notes were dictated, and we somehow coped. About in 2026, Council of Legal Education established, a committee led by Mrs. Funke Adekoya, Senior Advocate of Nigeria, to review the curriculum. And so in 2008, we had a review of the curriculum of the Nigerian Law School. And then since then, that committee recommended, and flowing from that committee, we had the vision statement and mission statement. Now, the vision statement of the Nigerian Law School presently is to be a model institution that aims to attain the highest standards of legal education and vocational training in the world, train lawyers grounded in the ethics of the legal profession who can respond to current national and international legal challenges in a diverse society, providing leadership in many different walks of life, and to maintain vocational training and capacity building for lawyers to be intellectually and professionally effective for meeting global challenges and ethical values. The mission statement of the Nigerian Law School, number 1, would include to educate and train law graduates in vocational skills that will enable them function optimally as baristas and solicitors, adopt skills-based interactive and clinical methods of learning that would adequately prepare the graduates for their roles as lawyers, to function as teachers, advocates, and to inculcate in its graduates the ideas of the rule of law, social justice, and community service. So we understand our role at the Nigerian Law School, that we have the duty to train and to impact practical skills to the students. Now, since the 2008 review of the curriculum, we changed the nomenclature given to the courses. We now have criminal litigation, civil litigation, property law practice, corporate law practice, and professional ethics and skills. Before, initially, professional ethics didn't stand as a course. It was included in all the courses, but after a while, it was brought back as a stand-alone course. But as it is, professional ethics is also infused in every aspect of each of the courses that we take at the end, currently at the Nigerian Law School. And then one of the beautiful things that this new curriculum has brought about is the fact that we now teach as a team. So you find out that in some courses, you have up to 4 lecturers going to class at the same time. And one of the benefits of this is that we are consistent. Students don't use us as, to settle scores, as it were. This lecturer said this yesterday, and the lecturer will not be in class. This lecturer has said this one now. So we all go to class together, and where whoever is leading the class or facilitating the discussion omits to say something, you find out that we send a note to ourselves, oh, you didn't say this, or you know, and invariably, after the overview, what we have is the interactive session. Before the interactive session, we would have sent at the beginning of the session, we would have sent the curriculum to the students. We would have sent the handbook to students. They have the list of recommended texts. And then we give them the task. Tasks are like questions to cover the entire topic. And we tell them that they should read ahead. Now, for those of us that left university, it was only recently, some years after I left, that I realized that some people during the long holidays spend time reading ahead of the following year, whereas some people will just do vacation job and be, just walking up and down. You now realize that they read ahead of the session. Currently, you have some students who are unable to come to the law school, and when they finally come, they say to us that they read ahead, maybe 2 times, they read the notes of textbooks 2 times over before coming to the law school. Such students wouldn't have issues, major issues coming to the law school. So what we tell them is that when they read ahead, the pre-task mainly to prepare them for to prepare them for receiving the lectures. If a student reads ahead, participates in the questions, we don't expect them to come with 100% content or knowledge, because if that were possible, then we wouldn't be necessary. It's just for them to realize, okay, this is this, this is this, and then when we now give them the overview, they correct themselves. When we now look through the questions taken that we would have sent, we would have marked before the class, we are able to identify their flaws, they're able to correct, whatever it is that they sent in, that they have taken in, and then by the time they go back to read, I want to believe that they will have a content of about 80%. So we would have sent the task. We have example of how this is done. In this current mode of teaching, we emphasize pre-class activities. We take the overview, and then we take class activities. Even though a lot of people say, yes, the law school, our classes are large, I can say that to a large extent, lecturers we know our students, because during the interactive, we don't stay on the stage, we move into the arena, as it were, and we ask them questions. Ideally, our students are divided into groups, so they submit their answers based on groups. But when we're teaching, when we're doing the interactive, we don't ask them based on groups. So, those who have been through, some of us know that we just randomly call the students. We know that in a campus you have 800 students. You can just say number 600, answer the question. And that means that you are focusing on group 10, 600, 610, 620. And then you say number 111. That means you are coming to group 1, get ready for to answer the question. So we move around and then we connect. It may seem impossible, but to a very large extent, I think that we were able to connect with some of the students. Some don't want to answer. Some, when you give them the microphone, they cringe, and some of them actually cry that don't give me the microphone, but we move to them, and then we have the interactive session. And at such times, we debrief, and we have the questions. Of course, they also have access to us. Another aspect of teaching currently at the law school is that we have special lectures. Now, the truth of the matter is we can't teach every aspect of the law. The truth of the matter is that law is evolving. And so the only way we can make up is to invite learned specialists or individuals who are versed in one area of the law to come and hold special lectures. I will mention that when it comes to assessments, because if your students know that somebody is coming to talk about AI under what topic, it's not going to be, no question will come out in the exam. They may choose not to come to school that day. So we have to find a way of balancing that, but we still have special lectures. A lot of associations and bodies will ask us that they want to talk to our students. Let me just leave that. Another aspect of this curriculum is the externship. We used to call it court attachment or attachment to courts and chambers, but now it's called externship. And the goals of the externship programs, number one, develop the extern's lawyering skills. Make the extern understand various aspects of the legal system and legal profession, inculcate in the extern the sense of professional responsibilities and values, and develop the extern's ability to reflect on and learn from those who have the experience. Now, one beautiful aspect of the externship now is that our students live with logbooks. In the logbooks, they're expected to tell us their activities and to reflect on one activity. If, for example, we say that bail is free, and in this matter, COP or state against ABC, and then bail was taken, and the lawyer said, I do not have 50 million. The question is, we were told bail is free. So in reflecting on what they have seen, they must tell us that this practice or what we have seen is different from what happened, and then maybe it's a case for which is able or, is something that can be appealed against, So we expect when we read, because each student will stand before a panel, and it takes about 30 minutes. When you look through their logbooks and we ask them questions based on what they have seen in court, and then when they come back from law offices, we expect them to come with what the sample of documents drafted. But we find out that in some cases, our colleagues, when they receive our students, banish them to the conference room and do not engage them in any way. Now, why do we send our students on externship? I'm sure one of the reasons is because during externship, they see firsthand. They get to the office, they know how a law office is organized, and it's like they're like apprentices in these law offices. So we expect that our colleagues will engage our students. The form of engagement that sometimes they come back to tell us that they only organize tutorials for us, and then they were asking us questions and setting back final questions. That isn't the essence of the externship. Let them go to court with you. Let them observe arbitration proceedings. Let them do everything that you do, except that they will not sign your letters going out. So that defeats the purpose or the essence of the externship. When our colleagues fail or see them as a nuisance and distraction and do not engage our students. At the law school, when we assess our students, the feedback, I've sent the questions, answer these questions, or even during the overview. Our overview now is not a question of classroom assessment through feedback. Have you written that? We don't do that anymore. We just lecture, we explain, and we between to let the students give us the feedback. Now, that actually takes a lot of time because you may ask a number of students and they're unable to answer our questions. I experienced that about 2-3 weeks ago. Just a simple, I believe very simple teaching on the Lagos Rule, Land Registration Law, registration of family representatives, and the mischief behind it. And I gave them a scenario, and the answers they gave me went off and off. I went round, and finally, I got a lady to answer the question. So it's time consuming, but we get that feedback from them. The externship is also, externship portfolio assessment is also a feedback. And the rule now is that a student that does not pass the portfolio assessment, even though he or she may pass the bar final exams, the results won't be released, and that student will have to go and repeat the externship, both the courts and externship to the law office. And then when they come back, they represent, and then we now release the portfolio. And then another way we assess our students, which a lot of people know, is the bar final exams. It is just one exam per session. For those of us who went to school earlier, we experienced the almighty June. Now, faculties of law now have exams in semesters. And you find out that students at the law school say that the work is voluminous, is one exam. It's because there's a shift in the mode of examining questions. We can't break into 2 semesters, as it were. Now, at the law school, maybe one of the things that the panelists will discuss is what should be the pass mark of at the law school. Currently, it is 40%. But I want to think that they will agree with us, and the chairman is that it is time that we should raise it from 40%. In other jurisdictions, you don't have, that means 200 over 500 in 5 courses. I mean, in America, in Canada, they don't have that. And in some courses, you don't even have a pass mark. What you do is you draw a graph which is highly mathematical, and it is benchmarked against the highest score. Maybe the panelists will recommend that should also be adopted. So we have that, and then we also have more than one attempt at the bar. I mean, several attempts at the bar. You fail once, you come back. After a while, we'll draw the curtain. Now, what are our challenges as an institution? Number one, the chairman mentioned the Legal Education Consolidation Act, which is under review now. But we find out that there are a number of universities that are teaching law, offering law as a course that are not recognized by Council of Legal Education. A number of them say NUC has visited, but Council did not visit, and then they still offer law. And so when you talk of backlog of students, the backlog of students is not because the law school has refused to admit, it's because each university has its own quota. So that we know we deal with you based on the number of quota that you have. A university has 50, a university has 100. We deal with you based on that number. So if you now bring 300, when your quota is 50, you are part of the reason why we have backlog of students, because we'll only take 50. And it's only if a university does not exhaust its own quota that will be able to take in some of your students that you exceeded in, when it comes to admission. In JAMB, I mean, we had a meeting with JAMB a few weeks ago, and JAMB's the executive secretary of JAMB said that when it comes to admission, the JAMB doesn't have any issue with vice chancellors. JAMB will face the admission officers. And so if a university starts law, number one, you are not accredited to do that. Number two, or where you are accredited, you exceed your quota, Then, like what the chairman said last week at the ICPC workshop, ICPC should be called in, but I think that we should deal more with our colleagues than just ask ICPC. It's something that should go to disciplinary committee, and it's something that it doesn't help our profession. That's the truth of that. Violation of quota, we've already, I've just explained that now. So if you have a quota of 50, no matter the pressure, because you realize that you can be reported to EFCC, ICPC, then you stick to your quota and look the Vice Chancellor eyeball to eyeball and say that you cannot go against the requirements of Council of Legal Education. We have funding and inadequate facilities. Well, the MBA president has said we should reduce the number of campuses of the Nigerian Law School. Even with the current number that we have, you still understand the issue of the backlog. Because when people come to say this person should be admitted, it seems as if we are visiting the sins of the university on the students who are regarded as innocent students of the university. We find that the law school has published the list of accredited universities. We've just done that again, and we will be doing that from time to time. So the issue of funding of the law school is one issue that we have. We have our libraries, internet, and such facilities are not good enough, or they need to be upgraded. I would like to talk about the issue of dysfunction of undergraduate programs. I'm not really passing any blame, but it's just based on what we have observed. You recall that when I started, I said this relay race, so 6 years primary, 6 years in secondary school, 5 years at the university, 9 months at the Nigerian Law School. Now, some of the students coming to the Nigerian Law School cannot report cases. So you give them Idudu and Okuagba, and you give them the citation. They don't go to the library. And it's not as if the law reports are not there. It's something that I have experienced, and I said, you've gone to a university, you have a law degree. How did you manage through the university without reporting your cases? We rely on what the lecturer says. In your Judo and Okumagba, the judge held, the court held as follows, 1, 2, 3, 4, and that's it. They fail to read dissenting judgments and the like. And so you find out that their quality of analytical skills and everything is poor, And we observed that we just concluded the receipt exams last week. And really, the question is, why are some of the people that we saw, why are they studying law? I'm not too sure. In our days, people were saying advice to withdraw. I'm not too sure if a number of universities, faculty of law, if they still do that, that if you are not fit, you cannot cope with the pressure, you could not cope with the demands of the faculty of law, then maybe they should be advised to go to another faculty. That means that if they come to the law school, it's not likely that somebody will sit for the bar final exams up to 4 or 5 times before passing. Because I tell the students that it's easier to pass the bar final exams the first attempt. By the time they're staying out and coming for 8 weeks revision, it's not the same thing. So if the university will help to prune, not because they're mean, but because they do not meet the standards, then it will ease what we do at the Nigerian Law School. We've talked about inadequate funding. The law school, for example, does not enjoy TET fund intervention. And we have said that it would be good if we enjoy TET fund, not because, TET fund intervention so that we can improve on our facilities. Wow. Disruption of academic calendar. Wow, 3 minutes. Okay, so you find out that we don't go on strike at the Nigerian Law School, no matter how bad it is. We find ourselves running two calendars, two sessions parallel. We've never gone on strike at the Nigerian Law School, and that shows our commitment to legal education. Thank you. We are talking about ethics. So you find out that at the Nigerian Law School, if you don't meet the attendance, we will prevent you from writing the bar final exams. If you do not pass the portfolio assessment, your bar final results will not be released. We have cases of discipline, and we also have, regrettably, that some of our colleagues will now come to interfere to say this, and that. Well, let me say, I'm happy to say that now we have introduced a policy of that we don't deal with parents at the law school. We have stopped dealing with parents so that if a child has an issue, let the child come before us. We've spoken about the unethical conduct of our colleagues in the universities. So going forward, we are introducing classroom solutions so that somebody that wants to teach on the business of law, for example, can be in Abuja and it will be projected to all the campuses. We have a quality assurance unit now. And we've heard now that we know and we review our curriculum from time to time. What we use now, we adjusted about 2 sessions ago. So, and we hope to also digitize in this. We have a mantra now that we're running with, which is ARISE: academic excellence, research and development, infrastructural rebirth, sustainability and stakeholders' participation, and enabled digitization. Let me speak concerning regarding sustainability and stakeholders' participation. Everybody here is a stakeholder. Every Nigerian is a stakeholder. And we've enjoyed intervention from governments. I mean, we all know Port Harcourt campus, Abuja, the intervention of the Honorable Minister of FCT, where Lagos, the Southeast, the Northeast governors, so a number of governors have helped us, individuals, organizations have helped us. But I want to use this forum to call on, especially those who will be celebrating 25 years next year. You know, you went to Kano, Abuja, Yola, and Kano, Abuja, Enugu, and Lagos, that in celebrating 25 years at the bar, don't just have a party or dinner. Go back to your campus and see what you can do, because you are also a stakeholder of that campus, and that will also help us in improving the legal education. So having said that, I want to think that we know that there is still room for improvements, but are we doing what we should do? I think we have tried and we are trying, considering the constraints that we have. But I want to think that the law school is trying, and but is there room for improvement? Definitely. But that will come with everybody coming together to play their part. I thank you for the opportunity you've given us to, or given to me, to present this keynote address. And I trust that when the panelists come up, they would add more to what we have said. Thank you very much.
Thank you very much. Please give her a round of applause as she goes. You know, it's very difficult for you to tell a teacher to come and give keynote address. And very soon we'll have about 2 vice chancellors join us to quickly give us their short keynote address. Please, let's put our hands together for our Director General once again. Thank you very much. I think we're going to have a walking tea break, so that in the course of the other 2 keynote addresses, shortly after the keynote addresses, we'll be unveiling what we have for you here today. So I think we can go ahead and give tea break in the course of the other keynote address. We have the Vice Chancellor of University of Ilorin, Professor Egbewole, Senior Advocate of Nigeria, is going to give his own keynote address virtually. Please tell him to unmute his mic. Please unmute your mic, Leonard Silk, sir. Yes. Prof, you can go ahead. If you can go ahead. Please, let's give him a round of applause, please. I believe his keynote should not last more than 15 minutes or less. Thank you. So please, we can go ahead with the tea break. Please let it be a working session, please, so that we can have the tea go around. Thank you very much. Please give him a round of applause again.
Thank you so very much. The Honorable Attorney General represented the MBA president, legal education, DG Law School, and other distinguished participants at this very important summit. My intervention is titled Advancing Education Reform in Nigeria, Progress, Problems, and Prospects. The conference has called attention to the fact that the keynote is a short keynote that is being added to this discourse now. And I have 15 minutes. The actual will try and keep within the time limit. The question from give a background of legal education in Nigeria that we have made transformative reform agenda and conclusion. The starting point, in my view, is to try and look at what education is. Aristotle and Nelson Mandela called attention to education, not just learning of facts, or rather training of the mind to think and connect with what the DG of Law School has said, talking about critical skill in learning, which I believe is education. I also want to call attention to the fact that legal education serves as an important function in producing legal practitioners with a vision of upholding justice and promoting the principle of law in a developing country like Nigeria. That is, when we talk about legal education, the focus is not just to produce lawyers, but to produce lawyers that will be interested in the development of the country. The question now is, the lawyers that we are training presently, are we actually attending to their minds intellectually, such that they don't just become lawyers, but also carry the burden and responsibility of developing the nation? For us, 21st century legal profession is not only confined to the courtroom or advisory work, but also extends to policy design, arbitration and dispute resolution, both locally and internationally, as well as to be financially compliant. This intervention will raise questions. One, is Nigerian legal education producing lawyers for the world that has existed, or lawyers prepared for the world to come? Two, we also need to ask whether the lawyers we are producing now fits the 21st century world of work. Are these lawyers, old and new, trained to meet 21st century legal challenges? In answering these questions, we want to give a brief background, but I want to assume that most of us in this room are familiar with the trajectory of the legal profession in Nigeria, talking about the colonial period, which is externally controlled, which is not within our purview. The fact that the Oxford England Committee came up and gave us the Council of Legal Education and the Nigerian Law School. And of course, what we are going through today, mandatory continuing education, was a function of the provision of rules of and in this exercise that we are undergoing today is a function of level 4 of professional conduct. But the question I want to ask is this mandatory professional development program, how well are we monitoring it? And that comes clearly to the executive of the MBA. How well are we actually implementing, and how well are we ensuring that those that are attending are also followed to the letter? Can Nigerian legal education evolve from being historically respected to becoming globally competitive? And from the submissions of the DG of the law school, it is clear that if we really want to be globally competitive, we must transform, we must innovate, and we must respond globally to be able to get the essence of this exercise. As part of the progress that we have made in the legal education space, we call attention to the establishment of the Council of Legal Education. And I want to also commend the Nigerian Law School for what has transpired over a period of time. For instance, we have encouraged digitalization and technological advancement. We have also ensured institutional expansion to provide a better access to a greater majority of Nigerians who wants to read law. And that also speaks to the point that the DG made, to the effect that they run back-to-back and they run parallel sessions to ensure that they meet this issue. Now, the big elephant in the room, in my view, is professional ethics and responsibility. We must ask ourselves, are we actually providing the opportunity for Nigerian lawyers to be ethically responsible as lawyers? As a lecturer in the faculty, I know what we do. And I know that when they now get to law school, they also complement that. But when we now leave the law school and start to practice the law, because that is the essence of the training that we have been giving to these young minds, how well are we monitoring this ethical responsibility? You get to court and see how our colleagues dress in court. You get to court, see how our we see how address courts. We get the court, see with their younger colleagues. These are issues that we need as very important and fundamental. No doubt, the scheme for lawyers has been largely successfully implemented by way of just identifying we need to do this, we need to do this, we need to do this. But how well are we doing them as far as the implementation is concerned? We have a few challenges even when we talk about progress, inadequate practical skills, and that leads me to externship that the DJ have called attention to. I believe a larger percentage of the 9 months should actually be given to courts externship, law firm externship, because the essence of the law school program is to actually expose these people to the rudiments of the practice, which ends up being modeled up because of the rigidity in the curriculum, in my view. I've called attention to the ethical issue, weak integration between academia and profession. What's the teacher, either at the law school or in the various faculties, to Somebody is disturbing this process now. Mute yourself. And of course, funding constraint. Talk about funding constraints, and I believe that's funding constraint which must be addressed if you really want to get the results that we desire. We talked about digital transformation of education. But digital transformation is not just about ability to use computer. It's not just about ability to solve the net. There are more important and fundamental things that ought to be done with legal education. And that should admit, please move to this first. We believe that it's important for us as a profession to identify in critical terms the IT and legal profession as a course of study. Yes, I know that a number of universities and faculties do this, but I believe that the exposure and the law school is also very important in this area. There is need for strategic pattern between academic bench and bar, and that takes me back to the need for the law teachers, the law lecturers, and the law school, and the faculties to be exposed to practice. Therefore, I believe we should go back to the 1992 decree that provides opportunity for law lecturers to practice their profession. Because how do you give what you don't have? Never that or none abate. I believe there is need for a stronger ethical formation at the level of the practice outside of just the law school. Of course, problem solving over memorization. What we need now is not for the lawyers to have all the laws in his or her hand, but law. We need to invest in faculty development, and when we talk about investing in faculty development, we should this continuous training should be one that universities and law school should take more than a costly look at other legal practice academic field. I also believe that there should be incentives for research and excellence, so that teaching does not become stagnant. As if lecturers are outdated, students will be trained with outdated knowledge. Well, this is one area that I believe that the leadership of the NBA should also take particular attention: remuneration of legal educators, both at the faculties and at the law school. Like the doctors, they have commerce, even as law lecturers. I believe that legal should have a specialized salary scale that would give opportunity for the big guys, like the president of NBA, to leave their practice and come into teaching. There's also need, but mentor and also enforce our regulations. The students go beyond focused learning. And for me, I listen to the DG Law School and I appreciate what they have. They have all known that the exam is not the best way to test the students' intelligence. So we must go beyond just exam-focused learning to be able to get to the root of the matter. In call attention to the need for strategy is shaped not only by politics or economics, but by the quality of the institutions that cultivate thoughts, discipline, professional ethics, and sustain justice. In Nigeria, access to justice, ethical advocacy, judicial excellence, and indeed the future credibility of the legal profession will depend substantially on what we do now with legal education reform. Now, talking about reform, yes, we talk about quota that has been given to each university, but I believe that if take is all this quota that we are giving to faculty that are not being we should go beyond that. Let every student that passes out of the faculty of law attempts an admission process into the law school through a structured examination in a way that we will be able to now say, oh, we have a space for 1,000, and we will pick the best 1,000 that passes at our exam. Second, we should also be able to come to a regulatory position in terms of number of lawyers that want to produce in a year. In all professions, there are such regulations. In engineers, we want to produce X engineers in a year. In accounting, we want to produce X accountant, chartered accountants in a year. It is time that we decide that we want to produce X number of lawyers in a year for ourselves. Our history has placed a great responsibility upon the upcoming generation. How well are they using it? How well are they seizing the opportunity? We have it on record. And when the moment for reform came, we did not retreat, nor did we surrender to complacency. We need to take fundamental steps to actually reform the way we operate now. We stood in wisdom, acted with confidence, and built a legal education worthy of the future. Thank you so very much. I hope I didn't explain more than 15 minutes.
Please, can we give the learned professor and vice chancellor a round of applause? Thank you very much. I understand our hands might be very busy at this time, but you will agree that Prof has agreed with the DG of the law school on so many facts, only that he added that we should make the remuneration for law teachers encouraging and enticing in a way that the president of the MBA will leave his law practice and come into academics. Mr. President, I know Mr. President would rather prefer to remain in practice and once in a while step into the classroom and teach. I'm one of the people who believe that law teachers should still be law practitioners. However, the next keynote speaker, I'm sure, might want to say one or two things about that, himself being a practitioner and an academic. Ladies and gentlemen, please join me to welcome a mentor, the Vice Chancellor of Imo State University, Professor Uche Fula Chukwu Maese, Senior Advocate of Nigeria. One of the things about Prof, as you will soon know, is that he is one of the pioneers of clinical legal education in Nigeria, one of the pioneer students or beneficiaries of clinical legal education in Nigeria. Please join me once again to welcome Professor Chukwu Maese.
Thank you very much. Please forgive me, I forgot to put on my glasses. The president of Nigerian Bar Association, my own dear friend, Afam Osigwe, the DG, Nigerian Law School, and the person who blazed the trail of today's discussion. The chairman of this continuing legal education program with me to hide under the existing protocol. I'm recognized in absentia, though he's around, Chairman of the Council of Legal Education. I appreciate the organizers of this workshop. I appreciate the executive of MBA. I appreciate two staff of my school who are here, the Dean of Law, Professor Siko Kuriesen, and PA to the Chancellor, or Chinanyeza Mechi. I also appreciate who herald the touch of innovation. Thank you very much. I thought I would be the first, so that if I talk, I run away. For me to speak the two giants, the DG and the learned SAN, the Vice Chancellor, who just spoke, you know that everything I'm going to say here will be anticlimax because we already have the climax. I will do my best. I am the president of MBA, Mazi, the president of MBA, a man of many parts. He had really done well in his presidency. Without any fear of contradiction, since 1993, joined the MBA, I regard him as the best president we ever had. Advancing Legal Education Reform in Nigeria Program, Progress, Problems, and Prospects. At the beginning, you know, you start talking after some other have done that, and eating. If you stay so long, you'll be booed out from the stage. So, MC, time me 10 minutes. If I don't finish, come and drag me out. Just like you gave the Attorney General 1.5 minutes, please give me 10 minutes. Set out here the state of the legal education in Nigeria. I will concentrate my discussion not on the areas already touched, but on certain fundamental areas. If we are to talk about legal education, we have to look at the foundation. Just like the DG pointed out that we start from primary to secondary to university and then law school. The foundation for law actually starts with secondary school. And that's why we have WAEC and NECO. And that's why we have JAMB. To read law in Nigeria, you must have passed 5 subjects at credit level in not more than 2 sittings. Not more than 2 sittings. Those in the medical world made their own 1 sitting. The 5 credits must encompass 3 compulsory subjects: English, mathematics, and English literature. So if you don't have, for English, we have no problem with English. In the 80s, when we went to secondary school, what you need to read law then was 5 credits, including English, and mathematics must be minimum of pass. What we call then P7 or P8. At a point, just like to read medicine, you don't, then in the 80s, you don't need English credit. What you need in English, or engineering, what you need is pass in English. Pass in English. At a point, it became compulsory. So for now, you must have credit in English, in mathematics, and in literature. The question we now ask ourselves is, what is the relevance of literature? How many countries of the world require that there must be literature before you read law? I'll give you an instance. Psychology, sociology, political science, history, economics, accounting. These are very wonderful courses that can form a background for law. In none of these courses do you require literature in WAEC. Now, what we have now in the present system is a first-class student in the Department of Political Science or Psychology who did not offer literature in WAEC cannot be admitted to read law, whether direct entry or post-UME or UME. If you have a student who read history and made first class, or economics and made first class, or political science or psychology, that student comes back to say, I want to fulfill my dream to be a lawyer. And that person did not have any credit in literature, whether from WAEC or from NECO, he will not be admitted to read law. You ask yourself, what is the relevance of that literature? I tell you that if it were now, I wouldn't have been. Because when I read WAEC, when I took my WAEC, the first one it was cancelled in my school. Second one, I went under school, re-registered English, Maths, Physics, Chemistry, Biology, Economics. I created them, went for read English, Chemistry, Advanced level, changed my mind from medicine to law. I took in JAMB, English, Physics, Chemistry, Biology to read law. That was JAMB. And I entered university, competed with those that read literature and government, and I became the best graduating student in my set. And we are having a situation in Nigeria, I don't know when they did it, that without literature, you cannot read law. We have heard about judges in overseas who read medicine before coming to read law. Mathematics, Lord Justice Denning was there. The judge that delivered the judgment in Combe and Combe was a medical doctor before reading law. That is why the law degree is neither a BA degree nor a BSc degree. It is called the Bachelor of Laws, LLB, and Law School BL. It is somewhere in between both law, both arts and science. But in Nigeria, we have limited it. The worst is that in JAMB, there is what they call in JAMB subject combination. If your son wants to read law now, he must look for the subject combination for law, which are English, literature, compulsory, then civic education, government, economics, religion, and history. So in as much as mathematics be made compulsory, if a student who wants to read law wants to take mathematics in JAMB, he will not be allowed to read law. So you see that we are meeting those that are naturally gifted into sciences, but who has a flair for analytical reasoning that is required for a lawyer not to enter into the legal profession. So we have to look into that. Then I looked at the Unsworth Committee here. There's no need pointing out the Unsworth Committee. But I would like to read out the essence of legal education as succinctly captured by the Unsworth Committee. Legal education should be a challenge to an individual to understand human nature, a stimulus to him to examine man's functioning in a society of his fellow men, and study the variety of ways in which his freedom can be promoted while his activities are controlled for the greater benefit of the community. And above all, it should be an intellectual exercise which puts the rules of law in their ethical, historical, and social context. It boils down to what I was saying. Those with the knowledge that will put law into this context are not allowed to read law simply because they don't have a WAEC in literature.
It's disconnected.
I'm rounding up. I'm rounding up because I won't repeat the words that have been said before. Then I pointed out the then calling to bar, both in England and in the United States too. I looked at it here. I believe that these papers, and in the United States, the difference between us and them is that number one, there is no law school. In the United States, there is no law school in the United Kingdom. The universities teach. The relevant law bodies accredit and examine. And once you have your degree, law will be 3 years. And it is immaterial what you read in your first degree, whether engineering. One of my brothers who is practicing law in Nigeria, engineering in the United States, before reading law. We pointed a problem. The problem is a problem of finance. Law and medicine have been turned into a money-making program, especially in private universities. Now, last week or last 2 weeks, we were here in Abuja for an interactive section with JAMB and all the heads of institutions to draw up the program of admission. JAMB told us public institution finish every admission by October 31st, so that private university could, that when we delay our admission, those that fail to make it in public institutions find it difficult to get admission elsewhere. So we must finish by October 31. Then private universities finish by November 31. So that those who couldn't get admission in public universities will switch over. So that tells you the problem of even private universities getting some students applied them directly from JAMB. because of the cost. Public institutions, we are trying, yes, government is trying to subvert the cost, but it's still not enough. A proprietor of a private university told me they are working hard to establish law and medicine so that we can crack. Then when you come and Nigeria, you are charging 5 million, 6 million to read law and medicine. Then we should have to look into it to regulate the cost of reading some of these things in Nigeria. One of my staff whose son didn't meet up our pass mark, I told him, allow your son to stay back and read and take the next jam. He mustn't enter at the age of 16 or 17. He said no. He went to a private university and paid them, because when you go there you'll be given a course you want. So he went to a private university and paid. By then, the fee in that private university was 1.8 million. Within 6 months, the thing moved to. Within another 6 months, the thing is now around 5 million. For a professor whose wife is a civil servant in the Imo State Civil Service, to be training their child to read law in such a school where he was compelled to pay around 5 million. He now came to me and started crying. Please, allow me to change. Let me bring my son here through. I said, why now? He said he was no longer able to afford, that the son would drop out of school. I said, okay, go and pick a change of university form and come back. We'll look into the results and know where to put your son. He went and came back. So I'm in trouble. I said, what's the trouble again? He said, transcript in this book, transcript. We use 10,000 naira to students who want to leave. That I went there to collect transcript and they said I must pay 2.5 million. So please, it is time we look into this. It is part of the problems of legal education. I have pointed out here also that we have around 140,000 lawyers in this alive, up to 200,000, including those who were dead. And the population of Nigeria is roughly 200 million. And we are still procreating at a very high rate. What is the need of limiting, like I have had on this day today, let us limit those who want to read law. So what is the need? The first reason is that Nigerian law school cannot accommodate. And no less a personality than the president had even suggested reducing the number of people in Nigeria, number of campuses. We can or we should limit those who want to study law. If the population of Nigeria, if you look at the diversification of all the areas of legal practice cropping up every day, where the lawyers can be, every lawyer is not for court. Multinational companies, they need lawyers. Banks, industries, foreign ministries. Why are we trying to cut down on the number of lawyers? Simply because the capacity of law school cannot carry, even at this stage now. No matter the justification. But the question is this: can a council, I know they are able to now, in which institution, in which of the programs, in which of the countries does a council set up an institution? Council of Medical and Dental Association of Nigeria, they moderate medical examinations, they moderate medical teachings, they do the external examination, but they have not a medical school. Likewise, Council of Nursing and Midwifery, Medlab, current for engineering. The countries where we borrowed our laws from Anglo-American jurisprudence. Council should itself, conjunction with the NUC, but to stipulate conditions for legal education and not to teach. So that we can accommodate as many persons as possible. If they regulate and not teach, as in other councils, they regulate external examinations. WAEC no secondary school, NECO has no secondary school, they are all councils. Council of Education should abandon the idea of teaching. Law school has served its useful purpose. But for now, let us go back to reality. And reality is that the council should abandon the idea of teaching and concentrate on the idea of laying down the standard and of call to bar. In view of this, I know it is 9 minutes now. I made the following recommendations. Number one, for your deliberation, the minimum requirement for the study of law in Nigeria should be creative subjects. This means that the requirement for mathematics and literature in English should be abolished. Subject combination in JAMB should be abolished. To read law, a student should be required to sit for English and any other 3 subjects in JAMB. Council of Legal Education, in connection with National University Commission, should perform the role of stipulating the minimum requirements for legal education in Nigeria. Thus, Nigerian law school should be abolished as an institution, and the role of legal education taken over by Faculty of Laws in our universities. In other words, its responsibility should be in line with that of other professional regulatory, like Council for the Regulation of Engineering, Medical and Dental Council, etc., etc. Legal education, which will be taken over by the universities, should be for a minimum of 7 years. The first 5 years is for Bar Part 1, the 6th year for Bar, and the 7 years strictly for internship. The Bar Part 2 examination shall be strictly supervised and examination conducted by Council of Legal Education. It should be noted that WAEC conducts exams, they don't teach. NECO conducts exams, they don't teach. Medical and Dental Council, Korean, Medlab, and all other councils, they conduct exams, they don't teach. Thus, universities teaching courses for the relevant professions must pass through accreditation supervised by the council. Who supervises Nigerian Law School? They do whatever they like. No person questions them. Yet they supervise their affairs for his persons. There is too much concentration of power in one person. Please don't kill me. I am through. Thank you very much.
Thank you very much, Prof. Prof, please, can you come back, sir? Prof, please, we'll ask that you, we'll ask Prof to kindly take a seat. Prof, please take a seat. And we would like to invite the Director General of the Nigerian Law School to join him on stage. When Prof was attacking private universities was when his time was up. As I was coming, someone whispered to me that he would say it's because you are teaching in a private university. But while I was standing here, he now started attacking the law school. And I saw the way our able DG was conferring with the chairman of council. I was nodding her head in affirmative negation. I could hear her palpably say that we cannot turn the Council of Legal Education into the Council of Legal Examination. I wouldn't know if that would be the position of the DG, but we also still have Professor Ebowole, the Senior Advocate of Nigeria, the Vice Chancellor of the University of Ilorin, still joining us online. It's now time for us to ask them questions. And we're going to take just 3 questions, maybe 1 question for each of them. 1 question for each of them. If you have a question, if you put your hand up, I'll just give numbers. Number 1, number 2, and number 3. Please, would you mind if you get the microphone to them? Number 1, please. Number 2, can you step forward a bit so that we are not... The second microphone, please. Yes, number 1 is here.
Thank you very much. I am Dr. Jonathan Ekwerusi. So my question would go to the last keynote speaker as well as the DG Law School. Now, I understand at the law school there is the Bar Part 1 program, which is for persons who study law outside Nigeria. Now, from the conversation we've had this morning, we now clearly understand there are lawyers who trained outside Nigeria without literature at the ordinary level or entry into university requirements. And then they are admitted into Bar Part 1, where they apparently don't do literature. The law school doesn't teach literature in Bar Part 1. So the reality is that we now have a hybrid system of lawyers. Lawyers who train abroad did Bar Part 1 and took the Bar Finance, with lawyers who train in Nigeria and then did the Bar Finance or Bar Part 2. Is there any kind of study undertaken either by NUC or the Council of Legal Education to compare the continuing relevance of the requirement of literature for admission to study law? Bearing in mind that there are now lawyers here who are practicing who did not take literature at the ordinary level. Thank you.
All right, thank you very much. We'll take all questions before we respond. Yes. Number 2, standing right here.
This question is straight. My name is Planza Jonathan, and my question is to the Council of Legal Education as to the proliferation of law faculties and open universities operating faculty of law that cannot, the student don't eventually get to law school. What are the mechanisms that the Council of Legal Education are putting in place to ensure that there's sort of regulation for this proliferation and the operation of faculty of laws in open universities that don't get to Nigerian law school? Thank you very much.
All right, thank you very much. Number 3 is Dr. Onoja. Okay, we'll take him as fourth, then his number.
Thank you. My question is for the Vice Chancellor. My question goes this way.
Sorry, there are 2 Vice Chancellors. Which of them?
Oh, not Professor Gbeole, the Vice Chancellor, Imo State University. Yes.
Okay.
Yeah. My question is, if the Vice Chancellor knows of any measures that can be taken against deans of faculties who collect 100,000 naira each from each student applying to the Nigerian Law School to have their forms dispatched to the Nigerian Law School, and the rationale, and whether that practice takes place in Imo State University. Thank you.
Okay, thank you very much. We'll take the 4th one and then one online. There is an online question, I think so we'll just take that.
Yeah, thank you very much. I am Professor Latoye, Dean Faculty of Law, Lagos State University. Because this session is question and answer, that's why I'll be short. Otherwise, I had a number of interventions. But my question goes to the DG of Nigerian Law School, the Director General of Nigerian Law School. She mentioned in matters of admission that deans, it's high time that deans of faculty started meeting the Vice Chancellor eyeball to eyeball. And I consider that to be risky or suicidal academically. It's like asking the DDG to look eye to eye to the DG of the law school or chairman of Council of Legal Education. Deans don't have powers for admission. So, but the question is, I'm happy that you talked about stakeholders' participation. And there you mentioned the issue of participation of MBA and all that. In those days, it used to be that these who are critical stakeholders in legal education used to be invited to the law school for meetings. At some point, that stopped. And we find out that there's a disconnect, when there is supposed to be a synergy between deans of faculties who are critical stakeholders. So is there anything in the offing, now that you're talking about reforms, that will accommodate deans of faculty and policy making and meetings at the at the Nigerian Law School? Thank you.
Thank you very much. Do we have anyone online? Is there any question online? Okay, we'll take that later, so let them respond to the questions. All right, we will start with the Director General of the Nigerian Law School, and then we'll go to the Vice Chancellor Physical.
Okay, thank you for the questions. Let me answer. I'll start by saying the VC. Let me respond to the VC first. He didn't raise a question, but he raised some issues regarding the continuity of the Council of Legal Education. Now, sitting down here is not a question of by virtue of office one, but it's not because of any. We should be careful that whatever it is we're preferring to solve or to improve legal education is a national interest. Now, law is different. That's it. If we want to copy that Koren and whatever has not admitted or they don't conduct exam, then why should Council of Legal Education conduct exam? Number one, our powers are statutory. Number two, I'll give you an example. A few weeks ago, some council members, we went on accreditation to a university. That university has been accredited by NUC to commence law. When we got there, that university is on the main road, a converted event center. And the office's classroom was the converted parking lot of that event center. We saw those who came to welcome us in black and white, and we said, are you law school student? No, no, no. We are in drama, we are in this, we are that. And we kept asking questions, asking questions, asking questions. I didn't mention this, but part of the problem I think we also have is that we have lecturers, with due respect to all, we're all colleagues, but let's say it as it is. We have deans of, lecturers in faculties that are highly itinerant. So we engage them, and we asked for a particular lecturer, and what we were told was, oh, he came in this morning, he's not feeling fine, he needs to go to the hospital, but he's also working somewhere else. And so we left him, and the following day we went to that other university, and we said, we went to University G, and we were told that you were not feeling fine. He said, no, that is finished with them, was only with them for 1 year. And somebody, it was cross-examination at his best. You know, the guy was answering our questions innocently, but he gave us information. And we just asked him, what courses did you teach last session? And he said, contract and taught. What year? 2 and 3. That means they have students in year 4. It was while we were in this University H that we got this information, only to realize that this university has graduated 2 sets of law students. Council did not go there. And so if we continue to say council should not regulate, council should not set the exam, those students will invariably come back and everybody will say council admin, council admin, council admin. Really, the truth of the matter is that we should, we can improve the process. Ask the students that come. When we are talking, we should talk empirically and ask them 5 years in the university versus 9 months. 9 months made up of 3 months of externship in the law school. Which one would you want us to tweak? And then let us come back to now say, okay, based on the empirical evidence, this is what we want to do. Now, EMBA Part 1. When the VC was talking, Chairman Chief Igige and I said, really, if you come in as a direct entry student, you are presumed to have a foundation. You would have had your WAEC, so that NUC now requires literature to open the veil behind your first degree. Seems to all, seems to me not right. Because we wouldn't have the cross-fertilization of, from medicine and sciences to come to do law. And I agree, because all this, when you take them out, then you are taking away those who can reason analytically. But that can also be solved when we now say, okay, we have these courses, or you are the faculty of law. Then we address you and assess you, objectively, and if you feel that you cannot cope with law, then you go somewhere else. But Part 1, what the law says is that if they have they're coming with degrees of law, we are not about to open and to ask them for literature. So if we want that to be done, then NUC needs to exempt those who are coming who want to do direct entry law, exempt them from literature, or if you have your first degree, you have your first degree. So there's no need to reopen SchoolStat and to check SchoolStat if you are coming in with a first degree or a PhD. Proliferation of law faculties and open university, the truth of the matter is, council now, we published, we are taking steps. Now, we've published the list of faculties accredited. We have now taken the step further to say that when we go to the universities, the information we require them on oath. Number of students, number of lecturers to see whether they've exceeded quota, and you'll be surprised that it's either they do not know the implication of giving us information or not, because when we ask them, these are your lecturers, full-time or part-time, full-time or part-time, they would have written everybody full-time, and we now find out that they're either part-time or they're on sabbatical. And we now say, go and correct this. Ideally, we should not say go and correct. We should just collect it and report to police that this information was given on oath, and we find them to have falsified information. So what we need to do now is that, from this, we are being encouraged also to take it, and I'm happy the chairman is there, to take it further, so that when we say we want to deal, we want to read, we want to do this, everybody will understand that it is part of reforming legal education. Open University, I think we've addressed it, and we will report the body of benches was asked to prevail on Council of Legal Education. And body of benchers last week said, no, everybody is doing his or her own role. And Open University was not accredited. No, Council of Legal Education did not go to all the teaching centers. And that's why when the 1,883, when they were admitted, we had to do remedial for them for a whole year before we accepted them or admitted them into the law school. So proliferation will be dealt with. Last week when Professor Loyede talked about universities and deans, universities with admission officers, he said JAMB does not deal with VCs. So that if your VC is telling you to go and admit, to over-admit, we won't deal with the VC. We will face the admission officer. And the most the VC will do will be to remove you as admission officer and put somebody that will listen to him. But you find out that if that person listens to the vice chancellor, the person will invariably get into problems with JAMB. So the same thing, if the dean cannot look at the, say no to the VC, it's not compulsory for you to remain the dean. Because if you understand that it's a misconduct, you have a quota of 50, and you allow the VC to make you sign that you are breaching 150. At the end of the day, you say law school is not admitting, law school is not admitting. You've exceeded your quota. There should be implications for such impunity. So if you say you don't want to look at you don't want to confront your VC, maybe if LPDC, legal practitioners disciplinary committee or council reports to EFCC or ICPC, then that you should weigh it, and I think we should rather err to protect the integrity of our profession than a VC that will serve a term and go and then leave you to manage the problem.
Thank you very much, Ma. I think we are running short of time. All right, sir. Mr. Vice Chancellor, Physical.
Thank you, Mr. Moderator. Two questions that were directed to me. One had to do with literature, whether there is a way we are comparing those with literature, lawyers with literature and lawyers without literature. I don't think such an exercise has been done. But, and I don't think that such comparison is necessary. We are talking about the right to education. And for a course like law, somebody wants to be a lawyer and you say you must have made a credit in literature. And we are asking what relevance? What relevance? And let me tell you the truth. Go and check most secondary schools. They normally pay literature as an alternative to another course, a science course. So either you do literature or you will not do physics. Or you are doing physics, you will not do literature. So somebody from that time is being limited based on his natural ability to develop himself into an area of study most suited for him. As we say, it's not fair. Then my brother there asked me whether I have heard that some deans collect money before sending forms to law school. It's like asking me whether some members of National Assembly collect money before passing a bill. There is corruption everywhere. I know of a university in the East, not mine obviously, where the Dean of Law, after every session of admissions, will start developing his land. And after the money finishes, it will wait for another level of law school admission. And at a point, the House of Assembly of that state, through the governor, had to summon the Vice Chancellor to come and answer to the allegation they are hearing about law school and the Dean of Law. Do you know there is a university in this country where House of Assembly took over the compiling of list of those who will go to law school? Because of the corruption that they saw in that, they imagined that they saw, because most of this is the rumor. Now let me go to my school. I'm not saying it because my dean is here. A student sent me a message and I said, if you are serious, put it in writing. Sir, one Sandra collected 1.2 million from me, promising me that he will use it to influence the Dean of Law for you to get a law school form. And the student paid. Now, he now had the guts to go and ask the Dean of Law. I hope you got the money I sent to you through Sandra. He didn't say which money. The Sandra was summoned. The Sandra said he gave me that money for another purpose, that it has nothing to do with Dean of Law and law school. The Sandra was a staff, a laboratory staff in the Faculty of Biological Sciences, a laboratory staff. I have suspended the Sandra now and set up a committee to look into it and report to council. So, corruption is everywhere. And I cannot stay here and start swearing that there is no dean somewhere who does not do such a thing or such a thing. But one thing is very clear. In my university, for instance, if somebody is traveling for a professional assignment, we approve money from that person for his hotel and for his flight. So, but there are universities. The problem of funding has been very difficult. And they will tell the students, contribute 10,000, 15,000, so that your lecturer will be able to travel to Abuja to go and return your funds. These things are there. But when the students pay such 10,000 naira, they go outside and tell people that they gave Dean 1 million. And my bishop, an Anglican bishop, called me on phone and said, I should look into what is happening in Faculty of Law, that the dean was collecting 600,000 to send people to law school. And I said, Bishop, please, I'm interested in what you said. Whomever that told you this, who says he paid, I will pay that person the money back from my personal funds. The Dean of Law said, I will dash that person 1 million. Bring that person out. Let him come and say it. And the Dean said, I will dash the person 1 million. I told him, I will refund the 600,000 you pay, including prosecuting the Dean. The bishop said, you people are taking this thing too far. You people are taking it too far and refuse to bring up the person, bring out the person. These are the things we see in the university. Our colleagues here who are dean will tell you that. That's why I continue to tell my colleagues, don't collect any gift from a student. I've never done, I was Dean of Law for 4 years. I started teaching in 1995. My students are here. Let them testify whether I have collected gifts. I don't collect gifts. I don't collect gifts from my students or their parents. When they give you 1 naira, they will go and tell the world that they gave you 1 million. So everything, we should be listening to rumors.
And of course, the comments of the chairman of the Council of Legal Education, Chief Ngige SAN. So on behalf of all of us in the Legal Education Committee, it's a great pleasure to present this token in appreciation first to our keynote speaker, Dr. Olugbemisola Odusote, Director General of the Nigerian Law School. Mr. President, please kindly do us the honor to present.
Well, I was having a talk with the DG, and I don't have a right of reply, and I'm a member of council. But I share the view that someday Council of Legal Education will have to rethink and look for a day that it will be like ICANN. So I've been called on to present this award of appreciation to Dr. Olugbemisola Odusote for your invaluable contribution to the 2026 MBA Legal Education Summit. We are grateful not only for your presence here, but for your incisive presentation and participation. And we hope that the outcome of this conversation will be one that will lead to an overhaul of our legal education system. We may not agree, but one thing is certain, our love and passion for the profession, and we'll do our best to produce the highest quality of legal practitioners. Our views may be in the minority today, but someday may be the respected view. And in a subtle response to Chief Ikemba, Chief Ngige, I would like to remind him that Lord Denny read mathematics, and he ranks among the greatest. But then, thank you so very much, ma'am.
Thank you very much. Well, you have all heard from a science student turned senior advocate of Nigeria, the erudite, distinguished Professor Uchefula Chukwumeze, senior advocate of Nigeria, the Vice Chancellor of the Imo State University, a cerebral scholar, an enigmatic, disciplined, and outstanding orator. We thank you for joining us and for sharing your knowledge. Mr. President, I will please invite you to present this award. Thank you.
Professor Yuyu Chukwumeze, it's good to see an administrator who is a nonconformist. And I enjoyed your views because they resonate with me. Yes, yes. I didn't say that though. So, Professor Uchefula Chukwumeze, Senior Advocate of Nigeria, on behalf of the MBA Legal Education Committee, send this valuable contribution to the 2026 Education Summit. And also hope that some of the views expressed here will be able to agree on them, harmonize them with the earlier position taken in the previous Legal Education Summit. And in the next few weeks, so that we will pay a visit to the Attorney General of the Federation and make a presidential of these views as that of the bar, and also send same to the law school and to NUC, and that all of us shall commit to working to ensure that these resolutions are not merely passed, but given effect. I have a few weeks left. I will soon be an outgoing president, but there's still much we can achieve before my successor emerges and takes over from me. Thank you so very much, Prof. I know it's not so easy. Bring it here. I share the views with you that so many of the courses people have been asked to write are useless. Credit pass and maths to read law. You never do anything mathematics all the days you read law. Of what use is it then? Thank you so very much.
Well, those online have helped us to thank our third keynote speaker. I saw the online waves and reactions and comments to Professor Wahab Egbewale, Senior Advocate of Nigeria, Vice Chancellor of the University of Ilorin, an outstanding scholar who has contributed immensely to jurisprudence and our study of law. Even though we cannot throw his award to him online, we have our member of the Legal Education Committee, Rukaya Abdulaziz, who is from the University of Ilorin, and will ensure that this award makes its way to the office of the Vice Chancellor, so we can entrust it to you. So I will again ask Mr. President to please present the award to Professor Wahab Egbewole, SAN.
Rukaya Abdulaziz. So as I'm looking at you, I'm seeing Professor Wahab Egbewole, SN, the Vice Chancellor of the Kwara State, University of Ilorin. Please give him our best wishes and extend this token of appreciation to him for his insightful keynote address. I know he would have loved to be here, but nonetheless, with technology, we didn't feel his absence. And we listened to him and he spoke to us loud and clear. Thank him on our behalf and give him our best wishes. Thank you so very much.
Okay, so we kindly invite a group photograph. We'd like to invite the learned senior advocates here present, Professor of Law, our DDGs, to come up stage to take a group photograph with our keynote speakers. Quickly, we recognize the presence of Yes, Professor Okolocha should get ready. We apologize for mix-up. Please join for the group photograph too. And shortly after the group photograph, you will give your goodwill message. The representative of the chairman, Nigerian Law Reform Committee, Professor CJ Dakas, Senior Advocate of Nigeria.
Thank you very much. Professor Yu Okolocha is representing the chairman, Nigerian Law Reform Commission. We also have the presence of Gunu Taidi, Senior Advocate of Nigeria, past General Secretary of the Nigerian Bar Association, and a member of the Body of Benchers. Please, I would also like to ask Professor Okori. Okay, he's there.
Thank you very much. Shortly before you leave, distinguished learned senior advocate and professor of law, we'll be unveiling our journal shortly. The chairman of the committee will do that quickly so that... Okay, so yes, professor from... Where's the prof? The representative of the chairman, Nigerian Law Reform Commission. The representative of the chairman, Nigerian Law Reform Commission. Yes, sir. Sorry, sir, I will take your short goodwill message now. Then, okay.
After the Law Reform Commission, we'll also invite the representative of the DG of NIAUS for his very brief remarks. Prof, we are sorry, sir. Sorry.
May I simply say all protocols observed? Professor Dakas, CJ Dakas, SAN, Chairman, Nigerian Law Reform Commission, attempted to come, but couldn't, as he is stranded in Jos. And leveraging technology, he has sent his address, short remarks, which I now crave your indulgence to read on his behalf. It honors me greatly to address you today at this very pivotal legal education summit. I would like to convey my heartfelt appreciation to the leadership of the Nigerian Bar Association for its unwavering commitment to enhancing legal education and for extending this invitation to me. Advancing legal education reform in Nigeria, progress, problems, and prospects. It's not merely a theme for deliberation today, but one which we, at the Nigerian Law Reform Commission, consider a call to action. The mandate of the Nigerian Law Reform Commission is to ensure that our laws and legal processes effectively serve the needs of both the populace and the economy. Legal education forms the cornerstone of this mandate. Without a vibrant, rigorous, and forward-thinking educational system, particularly in the legal arena, our efforts at law reform will be limited by capacity constraints. As a teacher, bencher, and former chairman of the MBA Legal Education Committee, I have observed that although our legal education has recorded commendable strides in education, by producing a succeeding generation of legal professionals, the rapid advancements in global science, commerce, technology, academic curricula, regulatory oversight, and the increasing dynamism of legal practice compel the adoption of a more innovative and globally competitive approach. I am particularly gratified that this summit will also mark the official launch of the MBA Standards and Rules on Legal Education. The establishment of robust, transparent, and enforceable standards is a crucial step towards enhancing institutional performance and ensuring the contemporary and futuristic education of our lawyers. We at the Nigerian Law Reform Commission are therefore happy, willing, ready, and available to partner with the MBA, especially in respect of legal education issues that require legislative initiatives. For example, the proposals that may require the amendment of the Legal Education Consolidation (ETC) Act of 1962, about which much has already been said. And once again, I deeply appreciate the privilege of this opportunity and wish you a very constructive and result-oriented deliberations. Thank you. Thank you again for me.
Thank you very much. Please let's give him a round of applause, and we apologize for the mix-up, sir. Thank you very much. So quickly, I will invite the chairman of the committee. Sorry, we are going into the next session. Shortly after that, we'll have lunch, right? So please, we want to launch the journal now. At the end of the whole conversation, we are going to launch the standard guideline, please. So quickly, the chairman will quickly launch the journal so that we can have the DD of the Nigerian Law School and other invited eminent guests here to launch the journal together. The chairman of the committee, Prof.
Thank you very much. I was just telling the representative of the chairman of the Nigerian Law Reform Commission that Professor Dakas was my boss when I was his alternate chair in this committee when we had the summit in Abuad. He was the chairman of this committee at the time. So we are very delighted that he is represented. Of course, for us as academics, the best way to gather our thought on what legal education should look like is through a publication. So as soon as our committee was inaugurated in 2024, and we started the consultation process, organizing regional workshops, webinars, we immediately issued a call for paper to publish a journal special issue on legal education and sustainable development that will gather the thoughts of academics. And given that one of the challenges that we've discussed is the issue of research, ensuring that academics are at the forefront of research, we thought we will publish this journal in a top-ranked journal, this special issue. So we're very delighted that the Journal of Sustainable Development, Law and Policy
at Afebabalola University, which is Scopus indexed, was found to be a suitable outlet for this special issue. I must therefore start by acknowledging and thanking the founder and chancellor of Afebabalola University, Are Afe Babalola, Senior Advocate of Nigeria, OFR, LLD, and of course, a known figure in the profession, for giving us this opportunity. He, in fact, singularly sponsored the printing of the special issue. So I think he deserves a round of applause. And as Chief Ngige SAN mentioned, the last summit was organized at Abuad. So we also include in this special issue the public lecture that was delivered by Are Afebabalola during that summit, which was never published. And it was an extensive keynote, so we have included it in this special issue to guide our discussions. So I must also acknowledge the editor of this special issue, Dr. Egosa Ekato, who is joining us online. He's an associate professor of international environmental law at the University of Derby in the United Kingdom. He has worked tirelessly to ensure that our thoughts are included in the journal and that the best, what represents the best of the more than 100 articles submitted are featured in what we are launching today. In fact, his committee reviewed more than 100 submissions, and after a thorough peer review process, 17 articles, which includes 1 book review and 1 public lecture, were accepted for publication. And of course, if I were to go through the 17 articles, we will be here for another 3 hours. But I can assure you that the special issue includes submissions from India, from the United Kingdom, from USA, from Canada, from Qatar, from South Africa, from Kenya. And of course, we also have a number of contributions from leading professors in Nigeria. And we believe that this special issue will indeed provide a source, an authoritative source of research and knowledge for academics in Nigeria and beyond to understand their role in infusing legal education with best practices that can spearhead sustainable economic, social, and environmental development in our country and in our continent. That said, I will therefore welcome the MBA president, PG of the Nigerian Law School, the chairman of the Council of Legal Education, yes, of course, the chairman of the Law Reform Commission, the chairman of INEC, who is ably represented. I would invite us to please join us to unveil the journal special issue. Thank you very much.
Please, the learned senior advocates here present and our DDGs to also join here for the unveiling of the journal. The Dean of Laws from various faculty, Lagos State University, we have Ambrose Ali University, yes, and the keynote speakers. We also have the Dean of Law, Chukwuemeka Odumegu, Ojukwu University, Professor Enright Okoli. Please kindly join in the unveiling of the journal. Then we also have the Dean of Law, Professor Gogo George Otuturu, Dean Faculty of Law, Niger Delta University. Prof. Sir, please kindly join in the whole process. Then representative of Dean of University of Abuja, Dr. Franklin, where is he? Okay. MBA president is not Elena Silk, yes. So we'll give it to the chairman of the
So, Mr. President, as I've mentioned, we have gathered 17 high-quality submissions from across the country and even from beyond. And these have been carefully selected and are now included in this special issue, which we hope will be a source of reference going forward on what legal education should mean from an academic standpoint. So we ask you, sir, to please unveil. Okay, all of us.
Chairman, Prof, continue to conduct the proceedings. All of us will unveil it.
All right. Mr. President, I will open it with your permission, and then oh yes, all of us can open it together. Thank you. Yes, keep clapping. That's good. Thank you. The representative of the Director General of NILS, is he still here? Okay. Yes. All right. Ozioma, join us, please. The co-chair of the Summit Planning Committee, the members of the Legal Education Committee. If you are here, if you are still here, please join us. Right, so we unveil this to the glory of God and to the service of humanity and the legal profession. Thank you. Thank you very much. I should say that I've also been asked by the committee that we should get all the keynote speeches delivered today to include in the next issue. So I hope you will avail us of your powerful lectures. Thank you very much. Thank you.
Thank you very much. Please, let's give our distinguished guests a round of applause, please. Thank you very much. We will go into the next session now. So, distinguished ladies and gentlemen, the President of the Nigerian Bar Association, learned senior advocates here present, distinguished professors of law, we will move to the panel discussion. Shortly after then is lunch, so we'll do that very fast. Sorry we have taken your time today, but I think very useful time. Without wasting much of our time, I will call on the panelists for the next session. The first on the list is Dr. Caroline O. Oba, Deputy Director General and Head of Campus, Nigerian Law School, Yanagwa. Please let's give her a round of applause as she comes to the stage. Please give her a round of applause as she comes to the stage. Dr. Caroline O. Oba. Please, can we settle down? We're going into the next session, please. Please give her a round of applause as she comes up stage. We have Mr. Bunyamin Babajide Lawal, Senior Advocate of Nigeria. He is a partner and head Abuja office of the Babalaki and Co. Please give him a round of applause, please. Leonard SAN came as early as 9:30. And he has been seated since that time. Please give him a round of applause, please. Thank you very much, Leonard Sik. We also have Professor C.J. Ubanyowu, Senior Advocate of Nigeria, Professor of Law and Dean, Professor of Law, Chukwuemeka Odumegu Ojukwu University. Please give him a round of applause, please. We also have other panelists that will join us. I understand they are just coming in from an event. We have Mr. Omoyemi Akambe that will join us. He's a managing partner, Sofunde Osakwe, Ogundipe, and Belgore. Then we have Oyinkosola Badejo Okunsoya, Senior Advocate of Nigeria. She's a partner at African Law Practice, NG and Company. She will also join us in the course of the conversation. But without wasting much of our time, we'll call our moderator, the Secretary of the MBA Legal Education Committee, and the Dean, Faculty of Law, Southern Delta University, Dr. Jonathan Ekperusi, will be moderating this session. Please, let's give him a round of applause, please. Our time is fast spent, so I believe within no time we should be able to wrap up this session and also wrap up the event for the day. Please, let's, while I hand over to Dr. Jonathan to moderate the session. Thank you very much.
Thank you very much, able Master of Ceremonies. And so as you can find on the program, this session is dealing with legal education reform in Nigeria, standards, practice, and the road ahead. Essentially, from the keynote speeches, you would find that the tone has been set for this session. This session attempts to look at how to bridge the gap between training at the law faculty, training at the Nigerian Law School, and expectations by industry. And when we say industry for the profession, we're talking about law firms, we're talking about those who work as in-house counsel, we're talking about practice as academics, and all of the areas of practice, including those in government ministries, departments, and agencies. And some of the sub-themes for this session, we're looking at the current state of legal education in Nigeria, achievements, persistent gaps, and the most urgent areas for reform. We're also going to be talking about the gap between what Nigerian Law School, law faculties and Nigerian Law School currently produce and what the legal profession and industry demands of new entrants into the profession. We're also going to look at curriculum reform, pedagogy, assessment and evaluation, and rethinking how law is taught and evaluated in Nigeria. And of course, the role of the bar, academia, industry, and regulators in driving and sustaining meaningful legal education reforms. And then the last not the least, we'll look at the road ahead, of course, concrete, actionable steps toward a more responsive, innovative, and globally competitive legal education system in Nigeria. And so starting with the DDG of the Yenegua campus of the Nigerian Law School, Dr. Caroline Oba. From your experience in the very operational processing industry for the legal profession, talking about the Nigerian Law School, what would you say are the critical gaps between training at the faculty, training at the law school, and the expectations by industry, those who engage young lawyers from law school? Dr. Oba, please.
Thank you, Mr. Moderator. Good afternoon, everyone. Before I talk about the need for improvement, which is what I would call gaps, I want to add to what my DG said during our keynote speech. Because before you talk about gaps, you should look at where you are, the progress made so far. And she elaborated on that, but I would just want to add some issues to what she said. The law school had moved from the traditional method of teaching, where students just listen passively, and moved on to experiential learning. In 2008, we adopted a new curriculum where students, it's centered on students participation. A typical class, we have 5 modules in the law school. Before a particular module comes up, we take each module per day. Before a module comes up, the students are given case studies with questions, and they're asked in their groups to look at the case studies, come up with their answers as to how they handle that case study, the case scenario given to them. They work in their groups because the law school, as one of its objectives, wants to train lawyers that know how to work in a team, develop people's skills that would enable them to function effectively in the law firm, which they will eventually get into after their call. The student on the day of the lecture, the lecturer just look at the key areas in what the DG mentioned as the overview and run the student through it interactively, the key areas on that topic. After that, the floor is left for the students to make what we call seminar presentation on those case studies given to them. If the topic is one that requires drafting, they will have come up with their drafts, which they project for other groups, because the students sit in their groups in the class. Other groups see it. After that group's presentation, the other groups are given opportunity to criticize, make comments on what that group has done. That's one area I wanted to add to. Secondly, with respect to the externship program she mentioned, the externship program is mandatory and is a structured program. The students are not just sent out to go to the court and the law office like that. It's a structured program, so much so that the law school produced a student handbook and a field supervisor's handbook to guide the field supervisors. Who are the field supervisors? The registrars of the court, and then the heads of chambers or whoever is delegated to oversee the law extent when they go for externship. This handbook dictates or outlines the objective of the externship program. The externship program is like a pre-call to bar pupillage program. So the lawyers in practice are told what to do with our students, how to help them inculcate lawyering skills, shadow them for the period of the externship, so that by the time they come out from the externship and come back to campus, we could say that they are already ready, fit for purpose lawyers after call. That's one area. Again, the law school new curriculum also incorporates clinical legal education. We have law clinics in our campuses where the students are exposed to real-life clients, albeit poor clients from the community where the law school is situated, or the underrepresented people of such communities. So they handle their matters, and where the matters is one that have to go to court invariably, the files are transferred to a legal practitioner in practice. This law clinic gives the students the opportunity to interview real clients, live clients, and to be able to draft processes ready for filing in court. Now, as to your question, whether there are improvements, because I won't call them gaps, there is always need for improvement. Like the DG mentioned, we have large classes. So the new curriculum is geared towards ensuring that every student participates in the experiential learning. But because of the large classes, we can't get every one of them to participate. That's a reality. That's an area of challenge. that you will not be able to get everyone. Some of them are still able to hide under the others who are very active in their pre-class discussions and meetings, and then in class presentations, some of them are able to hide and not present. So if such students get out, they may still be lacking in the essential learning skills that they ought to have imbibed. Another area of improvement is in the area of technology-enabled experiential learning. The DG did mention that that's one of the mantra of her administration, using technology, digitalization of the law school. Because without technology, there are some things we could do that will make the experiential learning better for the student, more effective. For example, you could use technology, AI, to have simulations that the students will watch. You have role plays that the students will watch and be able to see how a court session takes place in real life, how a client is interviewed in real life, how a law office runs in real life. Please, I would like to add that in the current curriculum we have in the law school, students role play. Some of the assignments that are given to them is to role play or simulate, for example, in the week when they are taught interlocutory applications. They come and simulate moving of motions. They actually move motions, and one of their colleagues will act as the judge. So they get a feel of what it is like to move a motion. Another area of challenge is what the DG referred to in her keynotes, is the fact that when we send our students on the externship program, despite the fact that the field supervisor's handbook is given to all the law firms where our students are sent to, we have some legal practitioners who don't align with the objective of the externship program. The students, when they come back and we debrief them on their portfolio, they tell us, these lawyers tell them, for now, what you should focus on is passing the bar finals. Don't worry about learning the intricacies of legal practice. Just pass your bar finals. So they tell them to go to their libraries and read. Then that defeats the essence of that pre-call to bar pupillage that would have helped the students to be ready after call to bar and be fit for the purpose for which they are trained. That's an area. Then on the area of the law clinic, the challenge we are having there is that the law clinic is, for now, optional for the student, that it is not a mandatory program. Students who are interested are the ones who subscribe to it. And that's an issue. And not many of them are interested because they just have this attitude that let's focus on passing the bar finals. So that's another area of challenge, that the law clinic, which would have exposed these students to live cases, is not compulsory yet. And then I also personally think that another area of challenge there is the fact that the students are only exposed to community cases like customary law issues, marital dispute, whereas they could be exposed to commercial matters involving entrepreneurs, small businesses, where they have issues, dispute, contractual, breach of contract. Matters could come out of that, and it doesn't even have to be pro bono, because the law clinic program in the law school for now is pro bono. It doesn't have to be that. It could be one that attracts a fee, but not for the student, for the legal practitioner who will eventually take up the case in court. And then this, okay, thank you.
Let me now go to the learner seek, Mr. Bonyamin Babajide Lawal, Senior Advocate of Nigeria. My question to you is, as a senior lawyer who over the years has been engaging fresh entrants into the profession, what would you say are the critical areas that require, some reform in terms of new entrants into the profession?
Thank you very much. Let me start by saying that some 20 years ago. Ms. Oba was my lecturer in law school, so it's a great pleasure to be sitting right next to her today. It's a great, great pleasure. But it's important to state that I know that the law school is doing a lot, universities are doing a lot, but I've come to realize that the Nigerian lawyer or the young lawyer that has just come out of law school, most of them have been trained to be exam ready, and they're not ready for the intricacies of actual practice. One of the biggest deficiencies I've seen is in procedural analysis. You have someone, he knows Kotoye and CBN says this. He knows Attorney General of Obeya Memorial and Attorney General of Federation says this. But you find out that the person has never actually, A, read the authority, B, the person just knows theory and is not able to apply it to the practical realities out there. So that's procedural analysis, there's a deficiency there. And then drafting. A lot of people have just been taught to draft with templates. So some of their drafts that they come up with are not up to scratch with modern day realities. Another area that I've realized is there isn't a lot of commercial awareness. So we have a lot of lawyers that are doing certain things because that is what they understand it to be. So you have a situation whereby, for instance, you have a person that is a plaintiff in a matter and is opposing a motion for extension of time. So someone that is coming from a commercial standpoint would know that the requirements or the needs of the client needs to be put forth first. Another area of deficiency is the area of the professional ethics. So professional ethics is taught as a course. So everyone just knows that rule this says this, rules this says that, and they cram it, but they're not able to apply it to everyday realities. So, and because of that, you also have issues of when these young lawyers join law firms, their time management skills, the ownership of the assignments that are given to them, they don't take ownership of assignments that are given to them. There's still some informality in the way some people are addressing emails. There's a lack of emotional intelligence on their part. So all these things are, the law school and the university cannot teach all these things. But these are very important skills that you need to survive in the real world. So I've come to realize that at least along those 4 lines, there's a bit of deficiency from the young lawyers that are out there because, like I said, they've not been able to transition from being exam ready to the practical realities out there. Thank you.
Well, thank you very much for those incisive contributions. Now to our third panelist. From what the law school rep, that is the DG of the Bayelsa campus, Dr. Caroline Oba has said, and from what the LNSIC has also said, what would you say the road ahead for legal education? What would you envisage should be the best approach? I mean, to our panelists sitting to my immediate left, what would you suggest as the way towards curing these 2 gaps identified by Dr. Oba and Mr. Lawal, Senior Advocate of Nigeria?
Thank you very much. I think we have to go back to the curriculum of the university and that of the law school. You see, the lawyers we produce, when we produce them after graduating from the law school, when they go into the law firm, they cannot apply the knowledge they have acquired from the system. So there is need for us to go back to the curriculum. You see, the curriculum we have in the university, you have where you have so many courses. Those courses, they don't teach procedural aspect of the law. Now, when that person graduates from the university, and law school, he is half-baked graduate. If he goes into a law firm, he cannot prepare affidavits, simple affidavits, contract notes, counter affidavits, and so on and so forth. So there is need for us to go back to the curriculum. When we go back there, we inculcate, we put in place something like legal drafting, advocacy, negotiation, client interviewing, legal research, file management. Now, something like in their year 2 in the university, let them go into legal writing. Let them know how to write. It will help them in forging ahead. Then in their year 3, they should do drafting. Likewise in year 4. In that of year 3, they can draft pleadings, they can draft affidavits and simple contracts. That of year 4, they can draft commercial agreements. Then in their year 5, they do advocacy and negotiation. So that when they come out from the university and the law school, they can, once they enter into the law firm, they can function effectively. But what we have today is that when you enter the law firm, you start to learn. It will take you about 2 years now for you to find your feet in the law firm. So there is need for us to go back to the curriculum to inculcate these things so that the moment a lawyer is called to the bar and he enters into a law firm, he can do something. So I think that is the step to be taken. Thank you.
All right, thank you very much. Maybe I should draw attention to the fact that talking about curriculum, there has been periodic review of the legal education curriculum in Nigeria. And I'm sure you may be aware that the NUC, not too long ago, came up with what is called the Core Curriculum and Minimum Academic Standards for Nigerian Universities, as the CCMAS, which I think the last review was just a few years ago, 2022 or 2024. So I think there have been some reforms in terms of the legal education curriculum, particularly at the university level. But I'll come back to you. So maybe I go back now to Dr. Caroline Oba. Now, you talked about the challenge of externship, that students are sent on externship, and many of the law firms do not appear to understand the philosophy behind sending students on externship, and that rather than expose them to law practice at that early stage, they are locked up in the conference rooms of law chambers, encouraged to just focus on passing the exams. Now, my question is, has the law school been engaging these law firms in terms of feedback when you receive students and you have these challenges? Has the law school ever communicated back to these law firms so that when subsequent set of students are sent to them, there will be a change in the approach? Dr. Oba.
I stated earlier that we have a field supervisor's handbook that outlines what we expect the law firms.
No, just hold on. You see, why I'm asking this question, you would understand that one of the philosophies behind this engagement, what the NBA through the Legal Education Committee is doing, is to bring together, let us welcome one of our panelists, popularly known as Lady B, Oyinkansola Badejo Kusanya, Senior Advocate of Nigeria, partner Africa Law Practice, NG and Company. And let me also say one of the candidates in this year's NBA national elections. She's one of the candidates for the presidency. You're welcome. So let me go back to Dr. Oba. The question I'm asking is that one of the reasons the NBA Legal Education Committee put together this summit is to bring together stakeholders so that we can identify gaps for intervention. Now, the law firm I founded, Excellent Solicitors, has been receiving law school externs over the years. But it would seem that we've never received any feedback from the law school
as to how we handle the students, what areas we would need to improve upon. And I'm sure I'll be speaking on behalf of almost every law firm that is working, because one critical area where practice lawyers have worked with the law school is this area of externship. And I'm sure it's a pro bono service we do. We are not paid by law school, but we are glad to do it. So I'm sure I'm speaking the minds of many law firms here. Has there been any attempt at feedback, not just the handbook you give when the students are engaged fresh from the law school, based on this experience you've had when students return? Have you ever sent out feedbacks to law firms, particularizing what you may have noticed from each firm and advising on what you would expect in subsequent engagement? Now, before you answer, let me welcome again another big wig in the 2026 MBA elections. Let's welcome Omoyemi Akongbe, Senior Advocate of Nigeria, Managing Partner, Sofunde Osakwe Ogundikwe and Bergori, SOOB Law. Is again one of the candidates for the NBA presidency in this year's election. Mr. Akongbe, you're welcome. So back to you, Dr. Oba. Please, may you put on the mic.
I will speak with respect to Bayelsa campus. During the portfolio debriefing of the students, we usually administer questionnaire to the legal practitioners who come around to be the external panelists for the debriefing. And the questionnaire has areas we would need feedback from them as to the conduct of our students during the externship and how they related with their students. So yes, at the Bayelsa campus, we do that. But I don't know whether at the law school as generally, whether we do, because the law firms are many all over Nigeria. But I know that when some students come back, if particularly their feedback is very bad concerning the law firm, that law firm is blacklisted and we don't send students there anymore.
Yes, thank you. So the question really is, there appear, from your response, there appear not to be a structured feedback relationship between the law school management and the law firms that have been engaging these students over the years. I'll come back to that. But before I come back, I'd like you to also prepare to deal with instances where law students are sent to firms that are no longer in existence. But I'll come back to you. So let me come to Lady B. Now, when the chairman of the Council of Legal Education, Chief Emeka Ngige, Senior Advocate of Nigeria, was talking earlier, he talked about the challenge of continuity, that the communique and resolutions of the last legal education summit that was held at the Alfred Balola University at Ado-Ekiti was not followed up with the subsequent administration. And in fact, there was a disconnect between the Olumide Akpata administration and the Afam Osigwe, Senior Advocate of Nigeria administration. So as an aspirant to the office of the President of the Nigerian Bar Association, what do you think that the NBA, as a critical stakeholder in legal education in Nigeria, should do in fixing the gap between legal education, that is training at the faculty and at the law school, and getting young lawyers ready for practice in any area of legal practice that they may desire?
Can everybody hear me? Good afternoon. Distinguished seniors, I see that the president has left. I recognize the first vice president of the NBA, other national officers here present, distinguished colleagues and members of the panel. I apologize for coming late. As many of you may know, we were invited to a meeting with the ECMBA as the aspirants, and we're just coming from there. So I entered the conversation midway, but I was very keen to attend this seminar because I'm one of those that believes that legal education in this country is in a mega crisis, not just a crisis, a mega crisis, and that the NBA has a pivotal role to play, even though the NBA has no statutory role to play in legal education. We have a pivotal role to play. Now, you talked about discontinuity between one administration and the next. And the chairman of the Council of Legal Education pointing out that that may perhaps be responsible, I wasn't here, but that may perhaps be responsible for some of the lack of readiness that we see with a lot of our young graduates from the law school. I think just from a policy standpoint, any policy is supposed to correct all of that. The number going into the law school is so huge that the law school is hardly able to cope. And the result is we have many lawyers who, in spite of their best efforts, are not fit for purpose. So what do we need to do? The primary responsibility, if the profession is to thrive, is for everybody in that ecosystem. And let's talk about the MBA, because here we are. We have a huge role to play to ensure that our newest members gain the benefit of what they're supposed to gain. When they access a university, go to school to study law, there is a minimum standard of training that they should expect. When they get to the law school, they have a right to expect to be trained to be fit for purpose. And so when they come out, and then we're now insisting on 2-year mandatory pupillage, all well and good, but we're not addressing the real issues. If we had the university system that was properly administered, if we had the law school, vocational school, that was doing exactly what it's supposed to be, then many people would not be advocating for pupillage. But even though pupillage is good to train lawyers in the norms and the nuances of the profession, we now say nothing at all about what they are to be paid while they're undergoing this pupillage, effectively entrenching a system of modern slavery. I disagree with that entirely. So, just as an aside, if we are to insist on pupillage in order to ensure that the lawyers are eventually fit for purpose, then it must come with a corresponding obligation to pay a living wage. And then let me be a bit radical before I stop talking. I've often questioned, why does everybody have to go to law school? Why must every lawyer be trained to become a courtroom advocate? Because that's essentially what the law school does. It leans heavily on courtroom advocacy or solicitor's work when there are so many new and emerging areas of law that don't require the kind of training that the law school offers. So isn't it about time we had a radical change of how we see how lawyers come into the job market? And if we agree that the law is a degree that prepares professionals for any aspect of professional endeavor, then our vocational training should reflect that. And people should be free to choose which path they want to follow. Thank you.
Thank you for your contributions. I'll come back to you. But it would appear that even though you were not here when Professor Yu Chukwumeze, Senior Advocate of Nigeria, delivered his keynote speech, he spoke apparently in the same wavelength. Professor Chukwumeze, Senior Advocate of Nigeria, called for the abolition of the law school.
I agree.
And here Lady B is saying that the law school needs critical reforms. That's why we are here for this summit. And we in the Legal Education Committee are particularly grateful that we're already getting to achieving the aim of this summit. Now let me come to Mr. Yemi Akongbe, Senior Advocate of Nigeria, who is also aspiring to be president of the NBA. You would observe that without intending it, I am sandwiched between two aspirants to the office of president of the Nigerian Bar Association. Now, Mr. Akongbe, Senior Advocate of Nigeria, my question to you, Now, when the chairman of the Council of Legal Education, Chief Emeka Ngige, was responding to Professor Chukwumeze, Senior Advocate of Nigeria, one of the comments he made in responding to the NBA president's position, which seemed to have aligned with Professor Chukwumeze's position, was that the NBA, in all its years of existence, has not made any contribution of any sort towards the programs of the law school. In fact, he stated categorically that the NBA has not even donated a single textbook to the law school. Now, as an aspirant to the office of president of the NBA, what would you say is your vision for bringing about the needed reforms in legal education, particularly the NBA's role in legal education?
Thank you very much, and good afternoon to everyone. And just like my sister, Mrs. Badojo Okusanya said, that we had to go to the ECMBA, hence the reason why so so that I get in here. And hello? Yes. Thank you very much for that question. I think it's a very good question that's at the core of what the NBA stands for. I believe that as a matter of vision, I want to see an NBA that is built on the conviction that the association should be a single, united body that offers real value to its members, take into consideration modern trends, such that regardless of who you are, where you are, the NBA delivers real value to you. Now, taking that forward further, it means that the NBA, as a stakeholder in the profession, has a lot to do with lawyers, students or aspirants to the bar, as well as the ones in the bar. And we should play a major role. If, as Chief Ngige has said, NBA hasn't done much, then it's sad to hear that. Sad because the Council of Legal Education, the NBA has always had nothing less than 20 members on that Council of Legal Education. So if we have 20 members on the Council of Legal Education that designs the curriculum and the way the law school functions, then it will be a major failure if this allegation is being made with 20 members in that particular council. That's one. Two is that if you don't pay particular attention to the lawyers you are bringing into the profession, and you think it's only when they come into the profession that you begin to take charge. You remember that the foundation is very, very important. If you don't have the rudiments already, there's not much that you can do. So I think that the NBA needs to see itself as a single united body that needs to work not only even with the Council of Legal Education, even other members in different demographies. What do I mean? We have the NALT, the Nigerian Association of Law Teachers. These are MBA members that teach in different universities. The NBA should engage them. The NUC, that develops curriculum for the universities, the MBA should also engage them in developing a curriculum that works with modern trends. There's so many emerging areas of law that the MBA needs to sit down and redesign. I am not one of those people that believe the law school should be abolished, because I don't believe that you throw away the baby and the bathwater together. What it needs is reforms. Look at the best jurisdictions in the world. How do they do it? If we say today that not everybody wants to practice law, therefore, not everybody should understand the procedure of law. In countries, and I always give you United Kingdom as an example, pupillage, going to law school is extremely important for you if you want to be a barrister. If you want to be a solicitor, you also must take the LPC. What you get taught at law school, it's not the same thing as what you get taught in the university. University is supposed to teach you about substantive law. But in terms of procedural law, how you approach a court, if you sit down with someone in the law school in England who wants to be a barrister, there's little emphasis on the way we train our lawyers here, where they say, how do you draft an affidavit? An affidavit must not contain prayers. It must not contain argument. It must not contain conclusions. No. You sit down, you have presentations. How do you do skeletal argument in the Crown Court? How do you do skeletal argument in the High Court? You stand up. You're being taught practicals. You're being taught how to write briefs of argument. These are practical things that the law school should be about, not the way it's being taught, theoretical, or what are the 4 ways of commencing an action, the writ of summons and the petition. All of that are in the rules of the various courts that you can know. But let them know how to cross-examine. Let them carry out cross-examination in court. That is what they do in England. And that is what I think the law school should be doing. That's number 1. Number 2 is that I also think law school should be privatized. And people just take exams the way they do in England. You can set up a law school, privatize it, have your students, develop your program for them, teach them the way people do JAMB in Nigeria. That way, it even saves the government the high cost that they're expending on the law school. So when you do that, we know that private organizations work better than government. If you have private universities and the law school only sets exams for them, I think that would, number 1, take care of the issue of the cost. Number 2, being privatized, it then affords people, there's competition. It's competition.
Very much, Mr. Moyemi Akongbe, Senior Advocate of Nigeria. It will seem that even though you initially said, I disagree with the idea of scrapping the law school, but in your conclusion, you came back to the same point that Professor Chukwumeze SN and the MBA President, Mazi Alpha Mosigwe, Senior Advocate of Nigeria, have maintained that the law school, particularly Council of Legal Education, should function like WAEC, like NECO, like the Medical Council, and like Council for the Regulation of Engineering. That they should not be owning and funding a law school. They should set exams. I think that's the point. Okay, all right. So you said there should be a hybrid. There should still be law school. All right, thank you. Now we come back to Mr. Bunyamin, Babafemi Lawal, Senior Advocate of Nigeria. The question I was asking Dr. Caroline Oba earlier about feedback between the law school and law firms. Because I'm coming back to this question because for us as a committee, it is a critical component of our mandate and indeed how we have tried to execute our mandate during this period. In one of the webinars we conducted or organized on clinical legal education, learning by doing, we emphasize the synergy between law school and law firms. As a senior lawyer, what would you say are your expectations from the law school on externship? Would you say the duration of the externship is adequate? Would you say that would you canvass as a suggestion or by way of reform that the externship program should be adjusted? What are your thoughts?
Thank you very much. I don't think that it's a duration thing. I think we're all stakeholders in this thing. So if the law school has drawn up a curriculum and part of the curriculum involves you sending lawyers or students to a law firm for internship, it is not, the responsibility now falls on the law firm to make sure that the program itself is effective. We've had instances in the past whereby some students come back and they say, oh, where I was posted to, they told us to only come once a week, or we should just sit down in the library and read. I can only take from the experience of my firm. The internship program, we take it very, very seriously. The training involves or includes the students getting to the law firm on time. We engage them in all of the activities we're involved in. If we're going to court, they prepare for court with us. If we have client meetings, they sit in on it. So the responsibility is not, so it is not, to answer your question, it's not the length of the externship that's the problem. If you engage people extensively for 6 weeks and you expose them to the practical side of things, I think the responsibility, like I said, goes back to the law firm to ensure that when these kids have been sent to you, you are supposed to give them the adequate training or expose them to the things as the law school had intended. Yeah.
All right, thank you very much. For time, I may not be able to go to many of the panelists, but Dr. Oba, I'll come back to you with this last question. So the question is, what's the feedback mechanism, as I asked earlier, between law school and law firms? Because you've complained about law firms not doing what the law school expected. Would you, are there measures that the law school is taking to send these things back to the law firm so that subsequent students on externship or subsequent externship for students would be better handled?
Thank you. I believe the current administration, given the frustrations we had in the past, that the legal practitioners do not align with the objectives of the externship, that there is measures being put in place to see before the students go for the externship, just shortly before they go, in collaboration with the Nigerian Bar Association, if we could get the chairman of the Nigerian of MBA branches nationwide, because when we're talking about this law firm, they are large, and it's quite difficult for law school to relate with them directly. So in the past, law school had related through the MBA to say we need to upgrade our database for law firms. You asked me earlier, you said you were going to ask me, what happens each time we send law extents to firms owned by people who had died, so these firms no longer exist? Now, why is that so? To cure that problem, we had reached out to the MBA at the national level to say, please help us so that we can update our database for our law firms. We didn't get any response. So with respect to your question, what was the feedback? We're looking at how, where shortly before the student proceed on extension, if we could have an engagement, maybe a forum where we interact with the legal practitioners directly to say, this is what we expect from you, why the students are out there with you. We expect that before they come back, like the Leonard Silk just said, if the lawyers do their part, the complaints the same lawyers are having, that this law student come out not fit for purpose, that complaint will not be there. We always like to pass the buck to the law school. For goodness sake, how many months do the students spend at the law school? You heard the DG say 9 months. Out of that 9 months, barely 6 months is spent with us. The other time, they spend it at the law firms. The current set we have now, they came in March. By May now, they've gone for extension. They'll come back in August and write exams in November. How many months did they spend with us? So it's a collaborative effort. We must all put our hands together to ensure we bring out lawyers that are fit for purpose, instead of playing the game of blaming the law school. So the law school is going to do that, sir.
All right, thank you. Maybe you are perhaps being too defensive. Let me say that it's not a blame game. This summit is to enable us think outside the box to address areas that require reform. And so I would appeal to you to take back these discussions, the ideas that have been shared here as feedback, so that the law school could undertake internal reforms, particularly in its dealings with law firms. And let me just say that the MBA has been updating the database. I'm aware, while I was in NEC, that NBA often sent out forms to law firms to update their data and to send to law school. All right, I think that this is the most we can take from the panelists for now. We'll take just 2 questions from the audience. And so if you have a question, please indicate. All right, that's number 1. Yes, any other person with questions? Number 2. Okay, so that it won't look like we didn't take any. Does anyone have any question from here? All right, so let's pass the mic to the lady over there for a question, please. So please tell us your name and the panelists to whom your question is addressed. Thank you.
Hello, everyone. My name is Omotayo Mary Dada, and my question is addressed to the DDG Yenagoa campus. And just to mention, I was also one of her students at the campus. So it's a great honor to be asking you this question. So my question is about the clinics you talked about that was created to give students experience. And I was also part of the clinic at the Yenagoa campus. It was very useful. I remember using a scenario from that clinic to apply for my master's. I used it as a work experience, so it was very, very useful, just to mention. So my question is, what incentive does the law school have for students to participate in this thing? Because to be honest, when you get to the law school, you are so laser focused on passing the bar exam, and every other thing seems like a distraction. So maybe what's the incentive? I know for me, I got a certificate, but it was at the end, and I didn't even know I was going to get a certificate. So that's one question. Then the other thing is, I don't know if it's a question or a recommendation, but the Leonard Silk also mentioned it, that I think one thing that the law school can also do, while it's still existing with all this talk of scrapping it, is that at the beginning of the session, when you have induction for students, it will be useful to bring in lawyers to say what their expectations are of these students. So Mr. Lawal should not be meeting these people and having all these complaints. He should speak to them before they go to the law school, because you have students coming in from various backgrounds, various levels of exposure. Then the other thing is also to expose them to the other areas that exist. So other than working in law firms, she mentioned it, there are so many opportunities. So you don't have 10,000 people trying to get into Olaniwa Ajayi or Babalaki and Co. when there are several opportunities for law students everywhere. Thank you.
All right, thank you. Please pass the mic to the gentleman over here for his question. That's number 2. Please raise your hand again so that I will easily identify. No, this way, please. This, here. I was told that since no one raised their hand here, someone, okay, we'll come back to you. Thank you. Please tell us your name and address your question to any of the panelists.
Good afternoon to everyone and to the distinguished panelists. My name is Obed Soludo. So I don't have, my question is not for any of the panelists in particular. Anybody that feels equipped to take it can just take it. My thinking, and I would like to get the thoughts of any of the panelists on this, my thinking is that in addition to perhaps changing some things in our curriculum, that our curriculum is actually too bloated. A lot of panelists and a lot of contributors generally talk about adding certain things and teaching more. But when we look at other jurisdictions around the world, I'm sure we're one of the very few where it takes 5 years to get a law degree and then an additional 1 year to be qualified. So I would think that it may be better to streamline our LLB process to maybe 3 or 4 years, maybe 4 years, because every other course is 4 years, to have basic, standard basic law courses, contract, constitutional, tort, etc. And I just want to get your thoughts on if you think having a 4-year degree course would actually minimize the quality of our legal education, or if you think that's feasible, it's something that we should push for. Then secondly, relatedly, talking about standards, What are your thoughts on raising the minimum scores for passing the bar finals? Like someone mentioned earlier, in lots of countries, it's minimum of 50%. We're the only ones that have it 40%. And maybe that is what is contributing to some of the complaints you might have about the quality of lawyers coming into the field and entering the job market. So what are your thoughts on raising the cutoff mark? Is it something you would recommend?
All right, thank you. Please pass the mic to him. But while the mic is being passed, it is clear from your intervention that you came late to the summit. These questions were addressed when Professor Chukwumeze presented his keynote. He talked about law duration, that's the LLB program duration, 3 years, 4 years, and all of that. And then the DG Law School talked about raising the pass mark from 40. So these issues were addressed earlier in the summit. Let's get your question. But I'm sure that when the papers are sent out, you would get fuller details.
Yeah, thank you very much. Just here now that this might be the final session. So, and I've not had the opportunity of having my own intervention. And it's good that you just mentioned now that it's like this session includes both question and intervention. So please permit me. And I want to start a question. Maybe he has to answer the question after my intervention. Directed at the SAN, Mr. Latif
Akongbe.
Akongbe.
All right,
Sorry.
yes.
So Latwe, in the Faculty of Law, lesson. So I'm glad he mentioned the issue of stakeholders when it comes to curriculum in the universities or reforms generally. So it's good, and I want to ask him how he intends to do it in the manner that we feel as stakeholders in the university should be done. You'll find out that in drafting curriculum, these are critical stakeholders sometimes are not involved. And we feel strongly that at all times, when MBA wants to do this kind of thing, I had an experience with the ICPC curriculum on issue of inclusion of teaching of anti-corruption in the universities. And all things were brought together. Within 2 days, marvelous job. You know, they put us together and they gave fantastic thing to. So MBA could also go in that direction. So he may spare his mind on how he intends to go that way. Now, to the DDG Yenagwa campus, just as you feared that they were passing the buck to the law school, the same way the people, lecturers in the university also feel that they are passing the buck. You know, in Yoruba land, they say, that's a crippled person whose, whose load is wobbled. They say, you are just looking at the upper side, you are not looking at the base. So, you know, there are lots of problems in the university that we think. Before I go to that, briefly I want to mention that to the DDG Law School that please, we should not be seeing it as passing the buck. We may express what we feel are the difficulties. Having a database by the law school itself in the digital age that we are now is something that is easy, even without going to the MBA. When you are sending information or posting any student to any law firm, collect their data. Follow up digitally. Get them to give you a report or something digitally. You can always harvest that. When you send to a law firm and it's not responding, the next year, you delete and move on like that. I think that will help a great deal and it's part of the thing you can take back. If I have someone who could also advise me, I'll take back to my universities and my co-deans so that we can improve on that. Now, the first point, about 4 points.
Prof, you summarize your thoughts.
Yes, I will summarize. I will summarize. Thank you very much. But you agree with me that this is important. That's part of the reasons we are invited, stated in the letter clearly. Thank you, sir. Now, the first issue is the relevance of technology in the universities. And that showed clearly during the COVID time. We leverage on technology to teach our students. But you find out that people hardly look at technological infrastructure in universities or in faculties. Do they all have? Number two, on the side of the students also, do they have the facilities to actually receive those lectures online? The experience has shown that during COVID, when you have about 180 students who are supposed to attend a class, each class, you have just about 60, 70. And students always come back to say it's because I don't have a phone and things like that. So how could that, so authorities could also think in that direction. How can we help the student to live up to expectation when it comes to learning digitally? Then number two, accreditation issue. The accreditation, what I mean, the accrediting a faculty should never be something that focuses on the lecturers, because most of the problems are infrastructural gaps. So the question is, when accreditation is coming, you find that most lecturers will all be running eta-sketa to ensure that things are put in place, apart from what the university puts in place, so that there is no de-accreditation, because the consequence might be that there's retrenchment. Lecturers are made to go. The question is, who should bear the consequences? The university should know that they are the one bearing the consequences, so that the accreditation will not lead to retrenchment, and they must continue to pay the salary of the lecturers, even when they stop admitting students, until they comply. So when policymakers should always include that in their, I'm summarizing. Then accreditation requirement. Accreditation requirement, one of which is issue of staff-student ratio. Then staff mix. Professors, so number, senior lecturers, so number, then bottom level, so number. You find that what universities do is strive to meet the minimum requirement, therefore leaving a lot of other problems. What is the problem? There are many courses that lecturers have to take. So there is overload. You know, teaching courses, teaching hours, and other. And when you tell some universities, we need more lecturers, then you are, but we met the requirement of the NUC. so number of stars, so level, so. What I'm saying in essence is that beyond the minimum requirement, regulatory authorities should always be looking at, okay, now what's the responsibility of the staff that we have, academic staff? How many courses do we have? You still have to engage more lecturers beyond that requirement. If you look at the CCMAS now, the current CCMAS, there are many courses that are being taught to non-law students. Non-law students, and that's not taken into consideration when you see is coming for accreditation. And the faculty of law everywhere is made to do that.
Prof,
How do
we may not be able to take you beyond this. We are
Well,
constrained for time. So what are your conclusion, please? Yes.
The last point. Yes. Thank you. And that is issue of retention of our brilliant students in the university. First class, you are discussing with them, you are doing well. We want you to be lecturers. And you know, lecturing, especially at the university, is a foundation of everything we are talking about here. If their lecturers are not there, or the brilliant ones are not there, it's a problem. So you now find that students are being discouraged from coming into academia for two reasons, at least that I've experienced now. One, welfare package of the lecturers. When you ask a student, brilliant student, I want to be a lecturer. After graduating, you remember we want to process your application. Say, sir, give me 2 years just to go into practice and come back. Going into practice and coming back is usually a point of no return. They don't come back. And another thing is the prospect of such brilliant students in the academia. Some of them have told me, sir, you know, I've always strived or wanted to be a son. But we find out that academia is not a means of getting there. So therefore, we don't think we can stay. So the point I'm not saying those in academic must be given equal number of censorship. It used to be more than 50 for non-academic, sometimes 9, 10 for. But the idea of now saying it is restricted to one is not only denigratory, it is discriminatory. And I think MBAs should pursue something in that direction and just leave it open. I mean, whoever merits it and all that, that's the thing. Thank you very much, sir.
Thank you so much, Prof.
I will pass other points to you.
Thank you, thank you. Please, let's give a round of applause for that wonderful intervention. Let me just say that some of your points have also been raised earlier, and I'm sure they will form part of the communique at the end of this summit. We want to thank our panelists. I know there was a question. Okay, our first Vice President, I can't shut you out, but 2 minutes, please, because we're pressed for time.
Thank you, Mr. Moderator. There's something that I think,
yes,
Mr. Moderator, I remember that Professor Uche Chukwuemeka mentioned this point of eradicating our law school. And that point was heavily amplified by our own dear president. And behold, Lady Bull also maintained that position. I am worried because the truth is, it's only Nigerian law school that give our students the training and discipline. If for university and Nigerian law school, you say discipline in law school is quite different. And you come out from law school a different person. If law school was extended, let's say, for 3 to 4 years, I'm sure Nigerian lawyers will be different from other lawyers. That discipline, that lecture, that compulsion they gave us in law school, if we allow it to go by eradicating the law school, I think we'll do ourselves serious disservice. If we allow universities to award the degrees and then call people to bar, we will no longer have the Nigerian lawyers we have today. Because you will see a university student slapping his father, slapping the lecturer. They do this university and go scot-free. But in law school, you then miss 1 minute of your time, you're in trouble. And so when you go to law school, you are a different person in your orientation. Let us not sell, or let's not allow that thing to go off. Most persons I know today from the West, from the North, it was in law school I met them. That bond that bind was in law school. And that law school make Nigeria's lawyer different. You're at university, you have the hope that I'll be going to law school. Give you a different impression about yourself. And so I am begging that let us look at the issue of law school specially and give it special attention. Thank you, sir.
Thank you. Now, so that there will be fairness, we'll give 30 seconds to each of our panelists to give their closing remarks, beginning with Lady B. 30 seconds, please.
I think the conversations have shown very, very clearly that radical change is needed. And Mr. First Vice, the idea is not to scrap the law school as in scrap the legal vocational training, but clearly it is no longer fit for purpose. And as nice as all those ideas of bonding are concerned, there's so many other opportunities for us to bond. It's what is more important is for us to produce law graduates that are able to work and thrive as lawyers. And what I would like to say as my final point, Dr. Ekwerusi, is that the administration that appointed the Legal Education Committee, this particular is coming to an end. I hope we will see before the end of this administration something from the Legal Committee that shows that the Legal Education Committee understands that there is a crisis and it needs to be addressed. And that the MBA's role in ensuring that the standards in the profession are met and exceeded must be more robust. It is unacceptable if, as you said earlier on, that the law school has not contributed a single book to the law school. We have a certain number of representatives on the Council of Legal Education. We must have a greater synergy. Because at the end of the day, the lawyers are coming into this association. So we must have a greater say and a greater stake in ensuring that we produce a crop of lawyers that are able to thrive in this century. Right now, our lawyers, the danger is that the lawyers that we're producing are obsolete upon qualification because the world has moved on. So we must form a greater synergy to ensure that the profession has a better crop of lawyers entering into it. Thank you.
So my final thoughts would, in a way, answer the question that Prof raised, that directed to me, and which is that I think that the NBA, just like some people have said today, and that's my point too, needs to play a more critical role in the training of lawyers, not just lawyers in practice, but from law school. NBA, there's so much disconnect, and like I said to you, my vision is to see a single united body that brings everybody together, focuses on training and modern trends. Now, if we want to talk about training in law school and university, the question is this: the critical stakeholders in university and law school, how many of them are in MBA committees for MBA to sit down with them and have that engagement? The other day, just last week, the ICPC did a training with all the dean of School of Laws. Unfortunately for me, I was in Kaduna Law Week. I really wanted to be there because they saw the need to teach anti-corruption at university level, and who are the people to Does the NBA have that? Do we have that agreement with Dean of Law Schools? Then the NEC is the second highest decision-making body of the NBA. How many NALT members are in NEC? I went for your conference in Abuja, NALT. I spent 2 days there, feeling the pulse of law teachers, trying to understand what you need. That is what the NBA should be doing. Have NALT members there so that there can be meaningful and purposeful engagement. If you don't do that, there will be a disconnect. We would think this is what you need, whereas that is what you need. The NBA...
30 seconds, please.
Sorry. The NBA, we are practitioners. We know the state of practice. We know the sort of lawyers we need. We know the foundation we want to give people coming into practice. What kind of foundation is to give them? We want original thinking. How are you teaching them? Are you teaching them to have original thinking, critical thinking? So these are the sort of things that NBA needs to sit down and address. And I believe that in the near future, we would have an NBA that will focus, on such things. Thank you.
Thank you. May I apologize to the other panelists? Our time is up. But Dr. Oba from the law school, 5 seconds, please.
Thank
5
you.
seconds. Let us see, please bear with us. The DDG Law School, 5 seconds, your closing thoughts.
The Nigerian Law School has undergone massive reforms in its curriculum and teaching pedagogy. The training lawyers by the law school to meet the purpose of legal practitioners is doable, is achievable. With the right tweak to its present curriculum and teaching pedagogy and collaboration from all stakeholders in the legal profession, we get there. Thank you.
Thank you.
Thank you. Mr. Moderator, sorry. I'm so sorry. I'm so sorry. I just wanted to state that Professor Latoke was my lecturer at Lagos State University. Mrs. Oba was my lecturer at Nigerian Law School. So it goes to show that we're all stakeholders.
Yes.
We're all in this together.
Yes.
Yeah, thank you.
Thank you very much. Please, let's give our panelists a round of applause, please. I think they've done very well in respect of this session. We'll now invite the chairman of the Legal Education Committee to come and present our little token to them. Please, let's give him a round of applause. Professor Damilola Olawuyi.
Well, you have all benefited from the wonderful insights shared by our distinguished panelists. And so I will invite the first Vice President of the MBA to please do us the honor of presenting this award. We really appreciate the insights that you have all shared. We thank you for your passionate interest in legal education. I second everything that the two aspirants have said, that what we are doing here today should not be a one-off. It should be maintained, and there should be no disconnect. So you have our prayers for your aspirations, and we hope that we will hear from you in the future. So the first Vice President, let me call Dr. Mrs. Caroline Oba, please.
It is my privilege to present this wonderful awards to you. From what I have heard from you this morning and this afternoon, you have been building young lawyers, building Nigerian youths to be responsible citizens of this great country. You've contributed so much that even a giant sitting by a corner was a product from you. We are grateful. On behalf of the Nigerian Bar Association Legal Education Committee, award of appreciation presented to you, Dr. Mrs. Caroline Oba, for your valuable contributions to the 2026 MBA Legal Education Summit, May 25th, 2026. Thank you, madam, and God bless you.
Bunyamin B. Lawal, Senior Advocate of Nigeria. I know your lecturers must be very proud for your great heights.
Distinguished colleagues, see this young man standing here. The university lecturer is sitting down there. The law school lecturer is sitting by the corner here. We can't say more than to say God has done so much for this young man. We are grateful to God and what he has used him to do. We encourage you to continue building younger lawyers, continue to do the good things they are doing. In the Igbo Palace, they said, continue to do the good works. Continue to do the good works. On behalf of the Nigerian Bar Association, Legal Education Committee, we give you award, we present this award to you, award of appreciation, presented to Boriyame B. Lawa, SA, for your invaluable contribution to the 2026 MBA Legal Education Summit. Today, May 25th, 2026. Congratulations.
Our distinguished Prof, Professor C.J. Obanyo, Senior Advocate of Nigeria. Thank you very much for coming, and we appreciate you.
Chairman, this prof standing here was the chairman of the Nigerian Bar Association MBA Agwata branch, my own branch. He is a professor of law and a senior advocate. Prof. CJ, as we always call you, congratulations for what you are doing. I discovered that some of your colleagues are here from your university, and some of your students also here. They are proud of you. Continue to do what you are doing. We appreciate you. The Nigerian Bar Association Legal Education Committee Award of Appreciation presented to Professor C.J. Obanyong, SAN, for your invaluable contribution to the 2026 MBA Legal Education Summit. Today, May 25th, 2026. Congratulations.
Thank you very much, Mr. First Vice President. I now have the pleasure of inviting a distinguished member of the bar, Mr. Philemon Jacobs, SAN, to please join us in making the next two presentations. Thank you very much for accepting to present. We have with us the Leonard Silk Latif Akongbe, SAN.
To my Leonard brother Silk, on behalf of the Nigerian Bar Association, thank you for your valuable contributions to this summit and for telling us that we need to have a synergy in MBA between the branch, the Council of Legal Education, and National. We present this award of appreciation to you for your valuable contribution to the 26th Education Summit. Thank you very much. Congratulations.
All right. So last but certainly not the least is our Leonard Silk Oyinkansola Badejo Okusoya, Senior Advocate of Nigeria.
They call you Lady B, but we call you Mrs. B. Thank you for telling us that we need to overhaul law school and its entire curriculum. But in all of this, you're telling us that we need to reform legal education, which is an appreciation for your valuable contribution to this summit. We look forward to a bar that will work, whether you or Emi Akambe or the other one that is not here. Congratulations in advance to the three of you. Thank you very much, ma'am.
Prof, you permit me. I just want to say, God bless teachers. Today, Doctor and Prof are seeing their product, a Senior Advocate of Nigeria. Incidentally, I didn't know BB went to LASU. My father was the first Vice Chancellor of LASU. And Prof and I were conferred on the same day. Yemi Akongwe led me to all the places where I did my son cases. And Dr. Ekperusi and I have enjoyed many interactions, former chair of Efun branch. And so God bless teachers, and please continue to enjoy the fruits of your labor as we, your students, continue to make you proud. Thank you very much for this award. Thank you.
Thank you very much. Yemi Akombe and I were also conferred on the same day. Thank you.
Thank you very, very much. So we just take a group photo, please. MC. Okay. What's your mic? Please join us. Can we have Dean of Law here present to come and join the photograph? If we have any Dean of any faculty here present to come and join the photograph, please. Then shortly after now, okay, after the photograph, please. Thank you sincerely for your patience. We're gradually coming to the end of this program today. Please, let's put our hands together as our panelists go back to their seats. Thank you very much. Thank you very much. Shortly after now, lunch will be served. But instead of going back and coming in, we just want to take a small session on review on presentation of the MBA standard and rules on legal education by the chairman of the committee, who will come on stage shortly to just come and speak to us about it in another 5-7 minutes.
and another 15 minutes, we should wrap up this program for the day. Thank you very much. The chairman, Legal Education, MBA Legal Education Committee, sir. Please, let's give him a round of applause, please. To walk us through the MBA standard rules on legal education. Thank you, sir.
Thank you very much. I understand that I'm now officially the one standing between you and lunch. So we'll make it very quick so that we can close and you will go for lunch. That was a very fantastic panel, and they've set the tone for some of the things that we will say. It is my great honor as chairman of the MBA Legal Education Committee to present to you the MBA standards and rules on legal education. I think some of the panelists, especially the two bar aspirants, noted that the aspirants for the president of the MBA, noted that we must not have a disconnect between everything we are saying today and the future. And I'm pleased to inform them and all of you that the MBA Legal Education Committee has been working very hard to codify and elaborate upon many of the things we have been saying. For many years, we have all expressed the need for comprehensive reform of legal education in Nigeria to produce practice-ready lawyers that have the business and market awareness of contemporary times. As we have heard today, the MBA has over the years organized conferences, workshops, and webinars to interrogate this topic. And as the chairman of the Council of Legal Education Chief, Emeka Ngige, SAN, said earlier, this includes more recently the 2022 Legal Education Summit that was held at the Afe Babalola University in Ado-Ekiti. And you may wish to know that our chairman then of the Legal Education Committee was Professor Dakas CJ, Dakas SAN, who was represented here earlier today. He's currently the chairman of the Law Reform Commission. And I was his alternate chair when we organized the 2022 summit. So this conversation has been on for a while. But what has been missing is that at no time did we take that next step of documenting MBA's position on what high-quality legal education is and should mean. So one of the key tasks and mandates given to us by the current MBA president, Maazi Alpha Mosigwe SAN, was, and I quote, to formulate the MBA's authoritative position on legal education reform, amongst others. So today, we are all here as witnesses to history, as we, for the first time, unveil and present the MBA standards and rules on legal education, developed by our committee, which represents a milestone step towards documenting MBA's position on what legal education should mean in this contemporary time. So, these standards and rules that I will be presenting to you are not designed to replace the already comprehensive standards prescribed by licensing authorities for legal education in Nigeria. Rather, they will add complementary and practice-oriented quality control aimed at ensuring that legal education indeed meets the needs of today and tomorrow. And on a personal note, I remember while I was studying in the United States of America, I remember that the fear or the beginning, as we used to say then, the fear of American Bar Association approval, ABA approval as they call it, is the beginning of wisdom for law faculties in the United States. Even if you have been accredited by the authorities and regulators as a law faculty or law school, as they say, If you don't have ABA approval, you have not started. And that is the same in England. It's the same in Canada, in Switzerland, in India, and so on, where bar endorsement is crucial to law school, to law faculty, to students, if they are to access funding and support of the bar. And that is in addition to the normal accreditation by regulators that are the equivalent of our own NUC and Council of Legal Education. So as we continue, we have all said today we need more resources. The MBA should donate. The MBA should do that. As we push the MBA to provide more resources to law faculties, the Nigerian Law School and academics, through endowment, our committee, of course, is sourcing. The MBA, in turn, can now have this document as a tool to allocate such endowment and resources only to universities and law programs that operate in alignment with the MBA standards and rules. These MBA standards and rules have been prepared after extensive consultation and engagement through regional town halls and workshops, webinar series, bilateral meetings, and of course, this Legal Education Summit, all aimed to collate perspectives of relevant stakeholders in the Nigerian legal, education, and justice sectors. The scope of the standards and rules has been displayed are wide-ranging, and I will at some point call Ozioma to just walk us through some of the key highlights. It is our hope that by implementing these requirements, we can together enhance the effectiveness and integrity of legal education in Nigeria and strengthen the profession's ability to contribute to socio-economic development of our nation. Of course, after Ozioma runs us through, we welcome your comments and thoughts as we finalize this document. Let me extend our sincere gratitude to the National Universities Commission, the Council of Legal Education, the Nigerian Association of Law Teachers, the MBA Lawyers in Academia Forum, the Network of Universities Legal Aid Institutions, NOLI, of course, and other key stakeholders that have contributed to this document. We also thank legal practitioners, judges, educators, as well as corporate and individual consumers of legal services who participated in our survey, including those who attended our regional town halls and webinars. We must again acknowledge and thank the president of the MBA, Mazi Afam Osigwe, Senior Advocate of Nigeria, for the trust reposed in our committee to take this important next step of formulating MBA's position. I also acknowledge the dedication and commitment of all members of the MBA Legal Education Committee, without which this would not have been possible. And so, to the glory of God and to the service of the bar and the nation, I hereby present this document for our discussion and use. Thank you very much. Ozioma.
Thank you so much. The chairman of the MBA Legal Education Committee, my chairman, Professor Lawi SAN, thank you for the introduction and the rundown. Please, can we have the standards on the screen? So we know we spent a lot of time. We don't intend to take too much of your time, but we feel that it's very important to have the perspective of everyone in this hall and those of us online on the draft that the MBA has created, which is supposed to serve as a policy document for the MBA. And the idea is, having been inaugurated as Legal Education Committee, we felt that it was important to see what is obtainable in some other jurisdictions. And for some of you that have attended our webinars, you know that we had guests from all over the world, including Dr. Karamanian from the American Bar Association, from Qatar, several other countries, and we've taken a bit from all of these people that have spoken and from our interactions with faculty members at our town hall meetings and at our other meetings, and we have developed it into a standard. We will share the soft copy with all those who are registered. We have your email addresses, but we do want to get your feedback as to some of the items that we have in the draft standards. Please just have it on the screen so that we can follow along. So for our, the table of contents, so like I said, it's supposed to be a policy document. It's not binding. The schools have their regulators. We have the NUC, we have the Council of Legal Education. Like Dr. Ekperusi mentioned, the NUC has already developed a CCMAS, and the Council of Legal Education already has their minimum requirements for accreditation. But like other bar associations around the world, it's important for the MBA to have its own standards so that when schools are able to obtain or are able to attain these standards, they will be recorded within the MBA's records, and it's going to be known that they have fully complied with the MBA standards and they are partners with the MBA, so that at all times where the MBA needs to partner with law faculties on any issue whatsoever, consideration will first be given to faculties that meet these MBA standards. So if we have it on the screen, yes, so like I mentioned, the MBA is going to have a system where faculties can, when they meet these standards, they can let the MBA know that our faculty is compliant and we need you to come and look through, inspect and ensure that it meets these standards as contained in the standards and regulations for legal education. And we want to be listed within your records of faculties that have met the MBA standards. So this will apply for any issues of funding, any programs that require MBA partnerships. We will only do that with faculties that have attained these standards. So the procedure is on the screen. There will be a provisional approval, after which there would also be a final approval. But apart from all of these, I just want us to go straight into the direct provisions of the standard. So in chapter 2, we have organization and administration. That's page 15 of 40 of the standards. And what we want is that all law faculties will have a full-time dean. A lot of these stipulations are in line with the already existing regulations. A full-time dean, and that the faculty must have the resources to discharge, the faculty must provide the dean with the resources to discharge the responsibilities of the dean. The dean will be supported by heads of departments and associate deans as required. We already have this. Academic staff, a law faculty shall have sufficient number of full-time academic staff. And of course, this number is not, it's not a fixed number. It will depend on the circumstance. So these are part of the things that the MBA with the committee that will be constituted will go to schools to determine. And then apart from issues of the faculty, which are pretty standard, is the same as what you have with the NUC and the CLE. But I just want to take us to, I'll take us straight to the part that is of concern to us, and I think that's the part that from the discussions, it's very, 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 very key. And that's the area of practical simulation courses and clinics on page 20 of the standards, which we will share with all of us. So what we've heard is that there is a divide, or there is a gap between the education and practice. And how we intend to combat this is by ensuring that within the law faculties, please let's go back to page 20, practical simulation. Within the law faculties, every student is exposed to practical simulation of the law. So apart from reading and passing exams and having, you know, what you have, your normal theoretical exercises, we need to have a practical simulation. So with all law faculties, it's important that faculties have practical courses, we have law clinics, and we partner with law firms or other institutions to ensure that law students are exposed to the practical aspects of the law. I don't know why it's not on the screen, but I just think to save time, this is the key part of the standards. It's essentially how we're going to ensure that education translates into practice. And Of course, I see that time is already fast spent, so I'm not going to dwell too much on it. But we are going to display an email address, and we are going to send out the standards. And we will welcome your comments and your feedback before we develop our final copy, which will then be approved and then launched by the MBA. So I don't know if there are any comments, if there are any contributions. We've been talking about the standards. If there are any things you think should be included, or from what we've mentioned, what can we include in the standards to make it more robust, to make it fit for purpose? We welcome your contributions. If we don't have any contributions now, like I said, we're going to have our email address on the screen, and we're also going to send out emails to all those who have registered and have put their emails at the registration desk. And I don't see any hands. I don't think. Okay, we have contributions. Okay.
For the purpose of the rapporteur, so that we can be able to put everything together as part of your suggestion, just like our co-chair of the planning committee has mentioned. If you have any suggestion, you can just raise up your hand. Okay, I think we just have one. Anyone from our teachers here? Any further suggestion, Prof? Okay, so we have two. So I think if we have that, we are good to go. So yes, three. Okay, good. So if we have these three comments, we should be able to wrap up this. Okay, so we'll give it to Prof first. Or we give it to Prof to wrap up. So, Mr. Come on, go ahead.
Good afternoon, everyone. My name is Ataba Agbo. May I please stand on the already established protocol for want of time? So mine is a suggestion, because from the conversations that have happened today, there's a strong emphasis on the need for us to make the teaching of law very practical for law students. So I've had the little privilege of going through some of the standards. What I want to suggest for us to be able to make law teaching or learning the law in Nigeria more practical, I think there should be a strong emphasis on the standards, on faculties, ensuring that students go on internships during the period that they may be able to make available for those students. So we see that some universities these days now make it mandatory that when students go on holidays, they should be able to come back and show evidence of internship. So I think if we have an internship board, and this recommendation is, I think it should flow directly from the Council of Legal Education. So I believe that the council can function in such a way that they can have subcommittees that may be regarded as the internship board. And that internship board should be able to have membership that at least recognizes some of the student structure so that they can also be a part of it and make their recommendations for every faculty to maintain that students should be able to go on internships so that they can have practical knowledge. And I also think that there should be a strong emphasis on the standards in terms of the quota system for faculties. The greatest problem most law students have when they graduate is the fact that while you're in school, you're not sure of going to law school, no matter how beautifully well you perform as a student. It doesn't make sense that a student goes through the school for 5 years, for example, and at the end of the day, the student can't go to law school because he has personal issues with the dean, no matter what your performance is. So I think that the standards should also be able to emphasize the need for competence for as long as going to law school is concerned, so that students, when they are going to law school, you are sure that if you put in your best as a student and you have the good academic qualifications to go to law school, your going to law school should no longer be subject to the whims and caprices of the dean. Thank you.
My name is Dixon Watu, NBA Kaduna. I adopt the already established protocol in this conversation. I want to suggest, there's this thing that has been bothering me. I think it would not be out of place if the council can suggest that the part-time law program that was scrapped as far back as 1999 be reintroduced. It's my personal suggestion. Please let me land. I thought, if National Open University, because some universities had a very good part-time program. It's either part-time or evening program. The same course content being taught by the same lecturers. And most of them who went through this evening program, as it were, are not doing badly in practice. Instead of having issues with giving so many students admission in national open universities and other universities, and they end up not going to law school. I think they could consider it. This is my personal suggestion. Thank you.
So we'll take the final comments for this from Prof. And I believe it to be short, sir, so that people can.
Yeah, thank you very much. Let me use the opportunity to thank the organizers, the MBA president, the chairman committee, and other members of committee on this 2026 Legal Education Summit. It's been useful, really. Now, the 2 points I want to raise is I want to stress further that MBAs should be the vanguard of pushing for special welfare package for law lecturers. They have it for our counterparts in the medical practice. And if an outsider, like a professional body, goes into the universities to canvass that, I believe that that call could be easily heeded. Now, the last point is the issue of entry level for academic persons, for legal practitioners. You'll find out that lawyers who want to teach in the university, if you have not been to law school, you could be a graduate assistant. If you have been to the law school, you could be appointed as an assistant lecturer. If you have your master's after law school, you have lecturer 2. And that's what it used to be. But at some point, because other faculties in the university, their own entry point for lecturer 2 is when you have PhD. So they now insisted that even lawyers, the fact that they have gone to the law school is immaterial. Everyone must be entering that assistant lecturer position. I will send information about that so that this could be clearer to MBA. But I think MBA should take that up on behalf of lecturers so that those who have been to law school, they have spent more years in training than other faculties. They should be allowed to start, if they have not done their LLM, they should be allowed to start as assistant lecturers. And once they do their LLM, it should be lecturer 2.
They will use it. Once they know that is we form part of their cumulative grade average point, they'll be more serious. So at the end of the day, we have the total lawyer we are talking about. That gap must be obviously be bridged. Thank you very much.
Thank you very much, Prof. I think those comments are very useful, but I believe most of the law faculties now are now including some of the things you've mentioned in the law clinic that we currently have. And for the issue of externship that Mr. Itabo mentioned, I believe some lecturers are already including it as part of their curriculum. For me personally, as a law teacher, one of the courses I teach, I make sure my students visit the court within a period of 6 weeks, not making it mandatory. And I tell them basically what they need to focus on when they go for that visit. I want you to see how bail application is moved. I want you to see how briefs are adopted and all that. So you make it flexible for them. You don't need to set up a time for them to go for externship. So I believe some of our teachers are already doing that. And I believe some of these suggestions will form part of our community at the end of this event. Thank you very much for those useful comments. Please, let's give them a round of applause, please. I think at this point, we will now take the vote of thanks. Okay, so we'll take the recap and vote of thanks. Where is Ms. Folashade Abiodun? Oh, okay, please, let's give her a round of applause. The alternate secretary of the MBA Legal Education Committee. Yes, okay. Please, shortly after our vote of thanks, we have the VIP session here so that our guests can come in here to have their lunch, and we have more than enough for you to eat. You know, they say the reward of a teacher is in heaven. No, you have to enjoy it on earth. That's why we have packaged a lot for you to be able to enjoy. So shortly after our vote of thanks and recap, our VIPs will move into this very place while others can go and have more than enough for lunch. Ms. Folashade.
Thank you very much. Distinguished speakers, our panelists, members of the inner and outer bar, distinguished professors, law teachers present there. And I will never forget to mention the students. Students that are here, say hello. Yeah, actually one of the major stakeholders here, so we thank you for staying with us till now. So just to do a short recap of what we've been discussing, as my chairman, Professor Lawuyi has mentioned earlier, over the years that this committee had been inaugurated, we have gone all through the length and breadth of Nigeria to gather thoughts together to come to this point. And just to do a quick recap of all that we have been doing over the years, over the years till now, and all that we have during this session, the panel session, the speaking session. And one thing that stood out is that, when we went out, they just kept saying that nobody wants talk show again. They want a talk with an action that will back it up. And one of the things that was mentioned by the chairperson of, the chairman of CLE, Chief Emeka Egige, SAN OFR, he mentioned that there's a gap between transition, that when an NBA president is handing over, it's always difficult for all that has been said to move to the next stage. And one of the things that we have come as a committee is to assure you that there is a good transition of all the resolutions. So we are going to be combining all the resolutions that have been made in the Legal Education Summit in the past. We are bringing it together, and it's going to form one of the bills. It's going to be one of our contributions to the bill. And we are going to be having a synergy with all other agencies. As talked about earlier, the AGF represented was emphasizing on the need for us and to synergize with other agencies like Federal Ministry of Education, to synergize with Federal Ministry of Justice, for us to be a very, very important partaker of the legal consolidation bill that is up. So we are going to be doing that. NLS made mention of the fact that they are short-funded also. We are taking that into consideration. They are asking that they should be part of TET Fund. TET Fund should not be for universities alone. This is coming from the Nigerian Law School. And they are asking that alumnus of school, alumni, that giving back to universities shouldn't be the only thing that should be done. Law school should be considered when alumni are giving back to the society. And of course, we have talked about the collaboration between Nigerian Bar Association and law faculties of each state. Of course, Nigerian Bar Association is a big one. We have several branches all over. Each branch all over the country should be able to synergize with the law faculty, to ensure the reformation of legal education. And so we don't want these events to just end. That is why we are asking for a sustainable stakeholder participation, particularly that there is something called evolution. We know that the bill that is governing legal education was made as far back as 1962. And so there is a need for us to continue to go over this, like this town hall meeting, the legal education reform, a consistent gathering like this over the years to continue to meet up with the global standard. And it's our law teachers, they made mention of the issue of review of admission process. There's quite a number of external interference, so admission process should be considered, and particularly the measurement, what you use to measure the yardstick for admission process. And again, the Dean of the Faculty of Law, Lagos State University, I believe that you were talking on behalf of the Dean when you said that Deans should be made active participants in legal education policies, sir. So that is taken into consideration. Then we need an intersection between the theory and the practicality of law. And we have to harmonize decisions with all the past things that we have done. We really want to thank you for staying with us till this time. We thank all our speakers. We thank all our panelists. We thank all the members of the inner and the outer bar for being with us. We thank all the law teachers, the professors. We thank the students particularly for being here with us. And we thank members of the press. We thank everyone. And again, we thank the Nigerian Bar Association. Yes, we thank the vendors. We thank the vendors also. Thank you. Thank you for keeping it down. We thank the Nigerian Bar Association for all that they have done, their contribution to this, and for their support. We wish everyone a safe and sound journey, and I will not complete this vote of thanks without referring to the Legal Education Committee members. We want to thank everyone, their participation, their contribution. Everyone had made sacrifice in one way or the other, personal sacrifice, including financial sacrifices, including personal movement and all of that. Time have been invested in this, and we wish everyone a safe and sound journey. Mercy, a safe and sound journey. Thank you all.